Chapter 6, Enforcing Child Support Obligations. Introduction. Since 1975, federal regulations have required each state 4D agency to employ contempt proceedings, garnishments, executions on real and personal property, and other remedies when appropriate. 45 CFR 303.6. The Child Support Enforcement Amendments of 1984 expand the list of remedies that must be made available to and used by state 4D agencies. This chapter surveys the enforcement remedies available to the child support attorney in most jurisdictions. The goal of each section is to explain the remedy, identify legal and practical concerns for each remedy, and report relevant case law from across the county. Sample forms for the more frequently used remedies appear in the appendix at the end of this chapter. In addition, the mandatory practices called for by the Child Support Enforcement Amendments of 1984 are discussed in depth. The remedies are not sequenced in order of importance or usefulness, except for the placement of income withholding at the outset of the chapter, if income withholding is not possible for an individual case. For example, if the absent parent is unemployed, the child support attorney should assess the appropriateness of other remedies. Program attorneys must refrain from always using the same remedy, for example, contempt, regardless of the facts of the case. The Child Support Enforcement Amendments of 1984 require that states develop and implement guidelines for determining whether tax refunds should be intercepted, real and personal property liens should be imposed, security should be required, or information should be provided to consumer reporting agencies in a given case. 42 U.S.C. 666. A. Child support attorneys should develop similar guidelines for use with other available remedies as well. In addition to income withholding, this chapter covers judgments, liens against real and personal property, levy and execution, garnishment, civil contempt, criminal non-support, interception of federal and state tax refunds, bonds and other forms of security, equitable remedies, reports to consumer reporting agencies, full collection services by the Internal Revenue Service, IRS, mandatory military allotments, and statutory examination of a judgment debtor. Income withholding. Child support obligations have been enforced with various forms of income withholding throughout most of our nation's history. Over the years, many states have used wage garnishments effectively. However, even where garnishment procedures are summary and wage exemptions are limited, the temporary nature of the garnishment remedy is often unsatisfactory. In the 1970s, many states enacted statutes authorizing an employer to withhold a portion of an obligator's paycheck each pay period and send it to the court that entered the order or directly to the family. Early versions of these statutes merely recognized the validity of voluntary wage assignments, and required employers to honor such assignments. As child support enforcement experts employed the concept more frequently, state legislatures began to enact statutes that authorized courts to order obligors to make wage assignments. Most often, judges would order an involuntary wage assignment as a condition of purgation after finding the obligor to be in contempt for failure to comply with the support order. This proved to be such an effective remedy that many state legislatures revised their statutes to expand the definition of wage to include other forms of income and to require judges to order involuntary wage assignments in certain circumstances. Wage and income withholding is a superior enforcement mechanism because it extends into the future. It also allows for arrearages, as well as current support, to be collected in installments that do not preclude the obligor from meeting his or her minimum financial requirements. In 1984, Congress recognized the efficacy of income withholding by enacting 42 U.S.C. 666 A1 and B, which require states to enact statutes that provide for mandatory income withholding in most 4D cases where the obligor is in arrears and his or her employer has been identified. The new federal statute is very specific, both substantively and procedurally, in order to assure state legislatures enact income withholding provisions that are effective, efficient, and that fully protect the rights of all affected parties. The requirements are based on the collective experience of the states that have enacted and implemented large-scale income withholding provisions. The federal statute requires that, effective October 1, 1985, income withholding be the preferred remedy. After that date, all child support orders which are issued or modified in the state will include a provision for withholding from wages, in order to assure that withholding as a means of collecting child support is available if arrearages occur without necessity of filing application with the state child support enforcement agency. Clearly, this requirement applies to all support orders that are established in the state, regardless of the nature of the proceeding, that is, divorce, separate maintenance, paternity, adult abuse, uniform reciprocal enforcement of support act, etc., and regardless of who brings the action. This provision was intended to permit someone other than the 4D agency to initiate wage withholding, for example, a private attorney or a custodial parent, pro se, and to make effecting the withholding easier for new 4D cases in which an order already exists. A few states have gained special exemption from immediately effecting wage withholding procedures. Most existing statutes that contain such a requirement call for a conditional withholding provision to be included in the support order itself. Such a provision fulfills a dual function. First, it encourages the obligor to comply with the support order voluntarily. Second, it informs the obligor regarding the consequences of non-compliance in advance, thus lessening the degree of notice to which he or she may be constitutionally guaranteed at the time when the withholding is initiated. In addition to requiring that a provision be included in every new or modified order, the federal statute requires that income withholding be effected in every case worked by the 4D agency in which an appropriate delinquency occurs. The statute allows the state some flexibility in determining what the triggering events will be, but state law must provide for withholding no later than the date on which the payments which the absent parent has failed to make under such order are at least equal to the support payable for 1 month. The absent parent may request that the withholding begin at an earlier date. The Act requires that the withholding occur without the need for any amendment to the support order involved or for any further action, other than those actions required under this part, by the court or other entity which entered such order. Actions required under this part refers only to providing notice, resolving contested cases, distributing collections, and terminating withholdings. This provision was apparently intended to remove all discretion from the court or agency administering the withholding procedure as to whether withholding should occur in a case, and to prevent state law from requiring a hearing in all cases. The federal statute allows state due process requirements to dictate the extent of the notice to be provided to the obligor after the triggering event occurs. The statute requires that notice be given on the triggering date. As a general rule, the absent parent will be entitled to an advance notice regarding the alleged delinquency and the withholding procedure. The notice, where required, must inform the absent parent of the amount of overdue support owed, of the amount that will be withheld, that the withholding applies to any current or subsequent period of employment, of the procedures available for contesting the withholding, and that the only basis for contesting the withholding is a mistake of fact, of the period within which the absent parent must contact the state in order to contest the withholding, and that failure to contact the state within the specified time limit will result in the state notifying the employer to begin withholding. Of the actions the state will take if the absent parent contests the withholding, including the procedure to resolve such contests. The requirement of advance notice does not apply to states that had a withholding system in effect on August 16, 1984, providing for other, and presumably lesser, forms of notice. For instance, the wage withholding statutes in effect in Missouri and California's on that date provide for notice to the employer, who is to notify the absent parent and continue to hold the portion of his or her wages until a hearing is held and a resolution is achieved. At the hearing, the only ground on which the absent parent may contest the withholding is mistake of fact. The Act does not define mistake of fact, but the report issued by the House Ways and Means Committee indicates that this was meant to be a very restrictive concept. Such mistakes of fact would include, for example, errors in the amount of current support owed, errors in the amount of the arrearage that had accrued, or mistaken identity of the alleged obligor. This provision is not intended to waive the withholding requirement if the obligor paid the past due support after receiving notice that withholding was being implemented. The obligor could not contest the proposed withholding on other grounds, such as the inappropriateness of the amount of support ordered to be paid, changed financial circumstances of the obligor, or lack of visitation. These issues are important, but non-payment of support should not be used to obtain relief with regard to these problems. They should be pursued independently through separate legal actions. Within 45 days of the date the advance notice is issued, the state must provide an absent parent who contests a wage withholding an opportunity to present his or her case to the state, determine if the withholding is valid, and notify the absent parent, if appropriate. For states in which the administering agency is the court system, the hearing generally will be the type of judicial hearing normally provided to a judgment debtor who contests execution on the judgment, the scope of which will be limited to mistakes of fact. For states in which an executive agency administers the procedure, an administrative hearing will be given. The Act does not require a formal hearing. Indeed, given the limited scope of the hearing, many states may opt for a less formal hearing. If the results of the hearing allow the withholding to occur, the administering agency must notify the obligor of the decision and serve a withholding notice, or order, on the employer within 45 days of the advance notice. The Act limits the amount of information that may appear in the employer notice to such information as may be necessary for the employer to comply with the withholding order. The employer must be required to withhold so much of the parent's wages as necessary to comply with the order and provide for the payment of any fee to the employer which may be required under paragraph 6a, up to the maximum amount permitted under section 303. B, of the Consumer Credit Protection Act, 15 U.S.C. 1673b. If there are arrearages to be collected, amounts withheld to satisfy such arrearages, when added to the amounts withheld to pay current support and provide for the fee, may not exceed the limit permitted under such section 303b. But the state need not withhold up to the maximum amount permitted under such section in order to satisfy arrearages. 42 U.S.C. 666, b. 1. The Federal Consumer Credit Protection Act, FCPA, determines the maximum part of an individual's aggregate disposable earnings that are subject to garnishment to enforce an order for the support of any person. These limits are 50% of disposable earnings for an absent parent who is the head of the household and 60% for an absent parent who is not supporting a second family. These percentages increase an additional 5%, to 55 and 65% respectively, where the arrearages represent support that fell due more than 12 weeks prior to the current pay period. 15 U.S.C. 1673b. The FCPA defines garnishment as any legal or equitable procedure through which the earnings of any individual are required to be withheld for the payment of any debt. 15 U.S.C. 1672, c. In addition, the FCPA preempts less restrictive state laws. 15 U.S.C. 1677, thus, the federal requirement will apply even in a state that does not incorporate the FCPA limitations into its wage withholding statute. Marshall v. Dist. Ct. 441b Judd. Dist. 444 F. Sup. 1110, E.D. Michigan. 1981. GMACV. Metropolitan Operation, 98 Miscellaneous. 2D 307, 413 NIS 2D 818, Sup.ct.app.diff. 1980. States are free to enact statutes which provide for greater protection of a debtor's disposable earnings. 15 U.S.C. 1677, Crane v. Crane, 417 F.Sup. 38, E.D. Oklahoma. 1976, Ferry v. Ferry, 271 NW2D 450, Nebraska. 1979. On receiving the notice, the employer must begin withholding the appropriate amount of the obligor's wages no later than the first pay period that occurs after 14 days following the date the notice was mailed. The Act regulates closely the language in state statutes regarding other rights and liabilities of the employer. For instance, the employer must be subject to fine for discharging any absent parent from employment, or taking other forms of retaliation, because of a withholding. In addition, the employer must be held liable to their state for amounts that the employer fails to withhold as directed. The Act also requires state law to contain provisions that make it easy for employers to comply with their responsibilities under the Act. As noted above, the statute may allow the employer to retain a fee in order to offset some of the cost of the withholding if the state permits a fee to be deduced. Furthermore, the employer must be allowed to combine all support payments it is required to withhold into a single payment, to be forwarded to the agency or court with a list denoting the cases to which the payment applies. The employer need not vary from its normal pay and disbursement cycles in order to comply with withholding orders, but it must forward the support payment to the state, or other designated recipient, within 10 days of the date the employee absent parent is paid. When the obligor changes jobs, the employer upon whom a wage withholding has been served must be required to notify the court or agency that entered the wage withholding order and provide specified information, and the state must notify the new employer to continue withholding from the obligor's wages. Similarly, state statutes must provide for terminating wage withholding orders in appropriate circumstances, such as when all of the children have become emancipated or when it is impossible to forward amounts withheld to the custodial parent because his or her whereabouts are unknown. In no case should payment of overdue support be the sole basis for termination of withholding. Other provisions require that the wage withholding be given priority over other legal processes brought under state law against the same wages of the obligor, and that the procedure be applied in interstate cases. Interstate wage withholding is discussed in detail Chapter 9. The Act also allows states to implement statutes which expand the definition of wages to include forms of income other than those normally included in the definition. Expanded use of income withholding procedures should change the principal method of enforcing child support obligations in many states. Moreover, the summary nature of the process, and the replacement of court hearings with administrative hearings in many states, will reduce the role of the 4D attorney in enforcement proceedings in cases where the obligor is employed and the employer is known. Nevertheless, the 4D attorney will continue to have an important role in overseeing the process in many jurisdictions, especially during the implementation phase. There will be challenges to the procedure in many jurisdictions as well. For this reason, every 4D attorney must become familiar with the requirements of the federal statute and regulations, as well as the procedure adopted by the state in which he or she works. Judgments. In most states, child support orders are enforceable by the same means as regular court judgments. The word order is used instead of judgment because a decree ordering support looks to the future. When it is issued, the order is not a judicial determination of a sum certain. Nevertheless, in most states a judgment arises on the date a support payment is due and not made. The judgment automatically increases as subsequent payments are missed, because any remedy that might be used to enforce the order would be by definition a post-judgment remedy. The obligor may not be constitutionally entitled to notice and a pre-deprivation hearing. See Sanchez v. Carath, 568 P2D 1078, Arizona. App. 1977. In other states, the order is not entitled to judgment status. In these states, it is necessary to reduce the arrearages to judgment prior to depriving the obligor of his or her property through an enforcement remedy. The procedure to reduce the arrearage to judgment can take many forms. The judgment can be established through a special proceeding filed under the original case number in the same court that entered the support order. In some states, the judgment must be sought in a court different from the one that entered the order, because the latter is a court of inferior jurisdiction and lacks authority to enter money judgments. In these states, it may be necessary to invoke a formal transfer proceeding, in addition to the enforcement proceeding, in order to get the case before the appropriate court. The most common procedure in such states combines the request for judgment with a contempt proceeding. Exhibit 6.1, in the appendix to this chapter, provides a sample prayer for entry of judgment. In states where the arrearage obtains the status of a judgment automatically, the total arrearage can be substantiated simply by referring to the court's payment record or by presenting to the court clerk an affidavit executed by the obligee. Once the amount of the arrearage is determined, the amount of the judgment can be noted on the record, or execution may issue. A judgment is advantageous in child support cases for the following reasons. A judgment may create a non-possessory lien against the obligor's property. See below for a discussion of the creation and use of judgment liens. The judgment may forestall the obligor's ability to seek retroactive modification of the arrearage. Post-judgment remedies require that less cumbersome procedural protections be afforded the obligor than do pre-judgment remedies. This can be particularly important in federal tax refund set-off proceedings. See John v. Regan, 584 F. Sup. 399, D.C. Michigan 1984. Should the obligor die, a judgment may be entitled to a higher priority in probate proceedings than an unliquidated claim for support arrearages. Indeed, a judgment may be a condition precedent to filing the claim. See Austin v. Austin, 364 So 2D 301, Alabama 1978. The burden of proof regarding payment, or other form of satisfaction, may switch from the obligee to the obligor once the arrearage is reduced to judgment. Reducing the arrearage to judgment may change the applicable statute of limitation, thereby preserving the collectability of payments that fell due in the distant past. Typically, the statute of limitation that applies to judgments is to 20 years. See Chapter 7 for a discussion of statutes of limitation as applied to support obligations. Establishing a judgment may limit the court's discretion as to whether enforcement remedies may be employed. Normally a judgment creditor has a right to use all available legal remedies. Should the obligor move to another state, the existence of an in-state judgment allows enforcement to be accomplished in state where the obligor is employed by a corporation that does business within the state, where he or she is employed by the federal government, or where he or she otherwise has property or wages that are subject to the jurisdiction of an in-state court. A judgment is entitled to full and credit in other state courts. Clearly, states that have conferred automatic judgment status on their child support orders are one step ahead of states in which arrearages must be reduced to judgment. At least two states, Oregon and Nebraska, have done so by statute. Child support enforcement attorneys who believe that automatic judgments could make enforcement easier should press their legislatures for such an amendment. Liens against real and personal property. The Child Support Enforcement Amendments of 1984 require states to implement procedures under which liens are imposed against real and personal property for amounts of overdue support owed by an absent parent who resides or owns property in the state. In stark contrast to the wage withholding requirement, the federal statute neither defines lien nor provides any guidance as to when a lien must be created. It does direct states to establish guidelines to determine whether or not to create a lien on a given case. As used here, the term lien means a non-possessory interest that a support obligee, or the state, by virtue of the assignment of support rights, obtains in a piece of real or personal property as a result of the entry of a support order, subsequent non-compliance by the obligor, and compliance by the obligee with all procedural steps required by state law as to the creation of liens. Procedural variances that exist in the states will be discussed below. This working definition excludes the wage lien used in some states, for example, Maryland to withhold wages from an obligor, and the possessory lien that a judgment creditor obtains after the sheriff seizes a piece of personal property pursuant to a writ of execution. A lien, as used here, refers to a slumbering interest that allows the obligor to retain possession of the piece of property, but which prevents transfer of the piece of property unless the lien is satisfied. A lien statute prevents transfer of affected property either directly, by prohibiting the recording agency from issuing a new title or deed, or indirectly, by providing that all subsequent interests in the property will be subject to the lien. The latter method is the most common. It works because subsequent potential purchasers and lenders receive notice of the existence of the lien during the process of transferring the title or deed. The potential purchaser or lender reacts to this cloud on the title by requiring the obligor to satisfy the lien, or obtain a release from the obligee, before agreeing to go forward with the transfer or loan. In real property transfers, the potential purchaser or lender discovers the lien through the title search conducted by the title insurance company. Personal property liens require notice to subsequent purchasers and lenders as well. but the notice usually is provided by way of a note on the title of the property, or by serving notice on a third-party possessor. Typically, the lien will attach to all of the obligor's real property situated in the county in which the support judgment was entered and/or has been recorded. In some states, for example, New Jersey, judgments are centrally recorded and create statewide liens on real property. As such, the lien document, if there is one, does not have to refer to specific property in order to prevent a sale or other transfer. In most states, the lien also will attach to property attained by the obligor after the lien has arisen. The lien will last for a number of years, depending on the statute, and generally may be revived for an indefinite number of additional periods, as long as the underlying judgment survives. The lien may grow automatically, as the arrearage increases, and even may take priority over subsequent liens created by other creditors if the statute so provides. Procedure to perfect. Procedures for establishing liens vary among the states. In a few states, the lien arises automatically upon the entry of a support order and the first incidence of non-compliance by the obligor. Most states require the obligee to take some affirmative act to create the lien. This act may be as simple as recording a transcript of the support order or judgment in an appropriate office of public records, typically the recorder of deeds for real property and the title agency for personal property, or as complicated as filing an independent action to reduce the arrearage to judgment, obtaining a specific order from the court establishing the lien as to an identified piece of property, and directing the appropriate public official to note the existence of the lien on the title or deed. The most effective procedure adopts a middle ground. The obligee files a certified copy of the support order, and perhaps attaches an affidavit detailing the amount claimed to be due and owing as of the date of recording. This latter requirement may not be necessary where the support order is payable to the court or other public registry such that the amount of the lien at any point in time can be determined by reference to public records. In addition to these two documents, it is customary to include a cover document requesting the court clerk, recorder of deeds, or title agency to file the documents and carry out any steps required by the statute to establish the lien. Exhibits 6.2 to 6.4 are typical lien forms. Once the lien is created, the obligee takes no further steps until immediately before the lien expires. At that point, the statute should prescribe a method to revive the lien. Assuming the case warrants further effort based on established criteria, the lien should be revived prior to its expiration. Failure to revive the lien may allow the obligor to dispose of property without having to apply the sale proceeds to his or her arrearage, and may cost the child support obligee a priority over other lien holders. Revival procedures vary among the states as well. Some states still employ the common law procedure. The obligee must obtain a writ of sine facis from the court that entered the order, or the court where the lien was created, if not the rendering court, and attempt service of the writ on the obligor. The issuance of the writ generally affects the revival, even if it cannot be served until after the initial lien expires, and the second lien dates back to the date of the initial lien's creation for priority purposes. Some states allow a judgment lien to be revived by issuance of a writ of execution at any time prior to dormancy. In other states, the lien must be revived by a separate action in debt, seeking the entry of a new judgment based on the first judgment and an allegation of non-satisfaction. The lien perfection procedure must be complied with anew in order to revive the lien. The second judgment lien attaches to property owned by the obligor as of the date of the creation of the second lien, and the priority of the lien is determined as of that date. Satisfaction and release. Most lien statutes contain provisions allowing for a voluntary lien release by the obligee, and establishing a procedure whereby the obligor can petition the rendering court for an order releasing the lien if the obligee refuses to execute a voluntary release. Such a release can be general or limited to specific property. In order to obtain a court order releasing the lien, the obligor generally must post a bond, provide other security, or satisfy the court that releasing the lien will not leave the obligee in an insecure position. Most liens either will expire of old age or be released voluntarily by the obligee. The obligor generally requests a voluntary release when he or she attempts to sell the property or borrow money using it as collateral, and the existence of the lien becomes known to the purchaser or lender. At this point, the lien becomes a powerful collection remedy. If the obligor wants to sell the property or obtain a loan, he or she must obtain a voluntary release of lien as to the specific piece of property involved. There generally will be insufficient time and grounds to petition the court for an involuntary release. Clearly, the obligee has a great deal of leverage in such a situation, but the obligee should not prevent the transfer altogether. The sale or loan is likely to produce a pool of funds out of which a substantial payment on the support arrearage can be made. If the transfer is a sale, it is likely that the obligor has some equity in the property after prior lien holders, that is, mortgagees, are paid off, otherwise the sale price would not be acceptable to the obligor. If the transfer is a loan or second mortgage, sometimes a portion of the loan proceeds can be applied to the child support obligation, or other arrangements can be made that are acceptable to the obligee. Where the obligee is the custodial parent, non-AFDC cases, the 4D attorney will need to confer with the parent in order to determine whether or not to release the lien based on the best terms available. Where the obligee is the state, the 4D attorney will need to confer with the state official who possesses authority to execute a release on behalf of the state. If that authority has been delegated to the attorney should follow policy in determining whether or not to agree to the release. Either way, the attorney should not insist on recovering the entire arrearage in return for a voluntary release, nor should the attorney demand that the obligor turn over all of the benefit he or she is to derive from the transfer. The collection will occur only if the transfer occurs. The attorney should negotiate for the best immediate payment he or she can obtain, and attempt to secure payment of additional amounts by way of some other guarantee as a part of the release agreement. Once the agreement is reached, there is usually a third party involved in the transfer, that is, a real estate agent, who is willing to act as escrow agent to facilitate the exchange of the lien release for the payment. This allows the purchaser to pay off the lien, thereby diminishing any insecurities the purchaser might have regarding the validity of the title, instead of paying the obligor and trusting him or her to satisfy the lien. A lien release is a contract and, like any other contract, must be drafted carefully so as to embody the entire agreement entered into between the parties. Moreover, lien releases are often the product of negotiations that can be quite unique. Furthermore, the result of the negotiation process can have profound effects on subsequent purchasers of the obligor's property, and the obligor's children, should something go awry. Thus, it is crucial that forms be tailored to each case, and the 4D attorney should be involved heavily in the negotiation and drafting of each agreement and release. The legal description of the property must be transcribed carefully from the deed, and the statement of exactly what is being released must be drawn narrowly. A poorly drawn lien release could be construed as a satisfaction of the entire judgment, or a limitation of the obligee's right to use other remedies to enforce any arrears that might remain. A sample lien release form appears in the appendix to this chapter. See Exhibit 6.5. In addition to executing lien releases, a judgment creditor occasionally is requested to enter a formal satisfaction of judgment with the court that entered the order. This may be particularly true in states where arrearages are entitled to automatic judgment status. A lien arises without the need of any affirmative act by the support obligee, and there is no central payment registry to act as an official record. A formal satisfaction is the only way a judgment debtor in such a situation can obtain a clear record. The obligee generally may enter the satisfaction by sworn affidavit or in person under oath. Levy and execution. In this section, levy and execution refers to the statutory procedure that allows a judgment creditor to obtain a court order directing the sheriff, or other similar official, to seize property in the possession of the obligor, sell the property at a sheriff's sale, and apply the proceeds, less the costs of the sale, in satisfaction of the judgment debt. Because execution is statutory, the exact procedure will vary slightly from state to state. As noted in the previous section, the Child Support Enforcement Amendments of 1984 do not define the term lien. In many states, a judgment creditor must take the steps necessary to create a lien prior to seeking levy and execution. Thus, the Act's requirement that a lien procedure be available could be construed to require that the lien holder obtain the right to enforce the lien by way of levy and execution, in addition to obtaining the non-possessory interest discussed in the previous section. In most states, such a procedure is already available after judgment is rendered. In any event, As noted in the introduction to this chapter, the State 4D agency must make use of proceedings to attach real or personal property if the state's law provides for such a procedure and the obligor or his property are subject to the jurisdiction of the appropriate court. Obtaining the writ. Generally, the levy and execution process is initiated by obtaining a writ of execution, or attachment, from the clerk of the court that rendered the order. In some states, the writ is issued by the court in the county where the property to be seized is located, regardless of the identity of the rendering court. In such a state, the support order or judgment first would have to be transferred, or registered, in the county where the property sits. The writ is directed to the sheriff of the appropriate county, or perhaps to any sheriff in the state, and orders the sheriff to levy on the property described in the writ and, after appraisal under specified form of public notice, to sell the property at a sheriff's sale. Issuance of the writ is usually a ministerial act of the court clerk, and as such does not allow for notice and a hearing, nor does the clerk have discretion to refuse the writ request if all procedural steps required by the statute have been completed. Most court clerks provide forms for making the request. In some states that require the support obligee to reduce arrearages to judgment prior to seeking execution, the judgment must provide specifically for execution before the writ can issue. In such states, the court may have some discretion regarding the language contained in the judgment. In these states, attorneys routinely should draft proposed judgments that provide for execution. The writ typically has a limited lifespan of less than a year. The expiration date specified on the writ is referred to as the return date. The sheriff must seize the property, appraise it, schedule the sale and issue public notice, hold the sale, and turn over the proceeds less costs prior to the return date. If the sheriff is unable to locate the property during the period of the writ, which should occur only for personal property, the sheriff will make a nulla bona return. Successive writs are referred to as alias and plurius, as appropriate. Seizing the property. The procedure the sheriff follows will depend on whether the property to be seized is real or personal property. Real property is easy to levy against. The legal description and street address will give the sheriff sufficient information to identify and seize the property. The seizure is achieved by placing a notice on the property, notifying anyone on the property at the time of the levy, and placing a notice in the office of the recorder of deeds. For personal property, the procedure is more difficult for at least two reasons. First, the property is often movable and thus difficult to locate. Second, the property may not be particularly unique in the community. As a result, the execution request should include very specific and complete information. The court clerk will transfer this information to the writ, enabling the sheriff to locate the piece of property. It may be desirable to accompany the sheriff to identify the property. If the property is capable of being seized physically and taken away, the sheriff will do so. If not, the seizure will be accomplished by some other act that effectively removes the item from the obligor's possession and notifies third parties that the property has been seized. This may be achieved by placing a sheriff's seal on the item in a manner that makes it incapable of being removed. If the item is seized physically, it will be transported to a storage facility maintained or arranged for by the sheriff. Notice of exemptions. In most states, certain types of a judgment debtor's property are exempt from execution. The exemptions are established by statute and generally protect tools of the obligor's trade, books, family heirlooms, and similar items from execution. Many states also allow the judgment debtor a homestead and automobile exemption in limited amounts. By statute, court rule, case law, or practice, the sheriff may be responsible for notifying the debtor of his or her exemption rights. The notice usually is accomplished with a form notice of exemptions provided by the court clerks or the sheriff's office. Often, the sheriff provides a verbal explanation of the exemption rights to ensure that the debtor understands them. The exemption process usually requires that the debtor choose the property to be protected by the exemption, substituting non-exempt property for the exempt property listed in the writ. Many states have enacted statutes providing that the normal exemptions do not apply to protect delinquent support obligors. The theory holds that the exemptions were designed to protect the judgment debtor's ability to provide for his or her family and should not be applied to frustrate the obligee's attempt to force payment of child support. The 4D attorney should ensure that the exemption forms and practices being used by courts and sheriffs in such states reflect the special nature of executions for child support. Notice and sale. Notice and sale procedures are set forth in detail by statute and may differ depending on whether the property to be sold is real or personal property. Once the sheriff has seized the property and appraised its value to determine whether additional property should be seized in order to satisfy the judgment, the sheriff must schedule the sale and provide the public notice required by statute. The notice may have to be accomplished by posting advertisements in a newspaper, posting notices in the courthouse, or other similar method. The statute also may prescribe the number of days in advance of the sale that the notice must appear, and the place and timing of the sale. For instance, some statutes provide that a real estate sheriff's sale must take place at a real estate exchange between the hours of 9 a.m. and 5 p.m. Personal property is often sold on the steps of the courthouse. Costs incurred in the storage and sale, along with execution and sheriff's fees, if applicable, are subtracted from the sale price, and the sheriff distributes the remainder to the judgment creditor together with a sheriff's deed to the property. The purchaser takes the property subject to prior liens and encumbrances, and subject to any right granted the debtor by statute to redeem the property by submitting the sale price, costs, and fees to the sheriff within a specified period of time. When the redemption period expires, the sheriff's deed matures into a regular deed. Practical considerations. Because storage and notice costs can be high and prior encumbrances cannot be avoided, the 4D attorney should take great care in choosing cases for levy and execution. The following analysis should occur prior to requesting execution. Are the prior liens or secured creditors? Is the market for the piece of property depressed, making it a bad time to hold a sale? What are the anticipated costs? Given the above, will the likely sale proceeds produce a significant payment on the arrearage? Will depriving the absent parent of the piece of property decrease his ability to earn or cause him to flee the jurisdiction? Prior liens and security interests can be determined by checking title records and other public records, such as the Motor Vehicle Agency or the Uniform Commercial Code Purchase Money Security Interest Registry. The likely sale price sometimes can be determined by consulting with the sheriff's office as to the price similar property has been bringing in recent months. Garnishment. Garnishment is a statutory procedure allowing a judgment creditor to seize a judgment debtor's property that is in the possession of a third person, and apply the property to the judgment debt. In the child support context, garnishment has been a very effective remedy in some states, and has been used to seize wages, bank accounts, workers' compensation benefits, pension benefits, and unemployment compensation benefits. It is generally a remedy with a limited time scope, usually days or months. Garnishment cannot be used in most states to collect current or future support. The amount of the garnishment is limited to the amount of arrears due on the date the writ issues. The future use of garnishments to reach wages will decrease markedly due to the income withholding provision of the Child Support Enforcement Amendments of 1984. Nevertheless, attorneys should continue to use this remedy to obtain other types of property. Procedure. The first step in the garnishment process is to compute the amount of outstanding arrearages, including interest, if permitted by statute. The custodial parent should prepare an affidavit to document the payments he or she has received from the obligor, especially with respect to any periods during which the order was not payable through the court or other official registry. A representative of the 4D agency should prepare a second affidavit if payments were to have been made directly to the agency for any of the applicable period. Next, a writ of execution or garnishment must be requested from the court that entered the order. The writ should direct the sheriff in the county in which the garnishee is located to serve the writ. If the absent parent is a federal employee or in the military, the writ may be served by certified mail, pursuant to 5 CFR 581. The execution request form, and the writ itself, generally will contain blanks for identifying the source of the judgment, alleging the arrearage, and identifying the garnishee. In addition to the writ, the sheriff will serve a notice on the garnishee, informing him or her of the effect of the garnishment, and instructing him or her as to the applicable exemptions for child support garnishments. This notice vests the court's jurisdiction over the garnishee, so it is crucial that the notice comply with all statutory requirements. See 6am.jur.2d, Attachment and Garnishment, Seconds 337. Some states require that the obligor be notified as well. Most sheriff's offices have pre-printed forms for this purpose. The 4D attorney should confirm that the forms in use accurately state the child support exemption situation. It is also a good practice to obtain blank copies of the notice forms and fill them out completely prior to requesting execution. The final document to be served on the garnishee is the interrogatory form. Normally, there are only 4 or 5 interrogatories, and these are designed to be easy for the garnishee to complete and file with the court within the time limits set by statute. The interrogatories require the garnishee to disclose any property acquired by the obligor during the period in which the garnishment was in effect. The garnishee also may set up any defenses to the garnishment that the garnishee, or the obligor, may have. On the return date, the garnishee delivers the interrogatory answers to the sheriff or, more often, mails them to the court and the attorney for the obligee. The court clerk then may issue a pay-in order, directing the garnishee to pay the garnishment proceeds over to the sheriff. Often, the garnishee will pay the proceeds to the sheriff or court together with the interrogatory answers. Occasionally, the garnishee fails to answer the interrogatories or to withhold and deliver the obligor's property, or the obligee's attorney will suspect that the interrogatory answers are untrue. The garnishment statute usually will provide for a subsequent proceeding allowing the obligee to seek judgment against the garnishee for the value of the property that should have been withheld and paid over to the sheriff. In some states, the obligation to answer the interrogatories may be enforced by way of contempt proceedings as well. Payment by the garnishee to the obligor constitutes satisfaction of the debt owed by the garnishee to the obligor. Thus, the garnishee is protected from double liability. Constitutional imitations on garnishment. The U.S. Supreme Court's opinion in the case of Schaffer v. Heitner, 97 S.It. 2569, 53 led to D. 683, 1977, prevents the use of prejudgment garnishments to obtain in rem jurisdiction over a debtor. This holding applies with equal force to child support and paternity situations except where extraordinary circumstances exist, such as, the defendant has been avoiding service of process. The defendant is about to remove his or her person or property out of the state. The defendant has conveyed or is about to convey property fraudulently so as to hinder or delay enforcement attempt. Where such extraordinary circumstances exist, it still may be possible to initiate an action to establish a support obligation, or establish paternity, by seizing property of the debtor that is in the hands of a third party in the jurisdiction. Procedural hurdles may include an ex parte hearing to establish the existence of the extraordinary circumstances, to devise an appropriate form of service of process on the obligor, and to set the amount of the bond to be filed by the obligee. With respect to post-judgment garnishments, and income withholding, the chief constitutional issues are, 1. The time, manner, and extent of notice to the absent parent, and, 2. The timing of the hearing. The Due Process Clause of the Constitution provides certain protections to individuals whose property or liberty is being affected adversely by the state. Due process, of course, is a variable concept depending on the individual requirements of each case. The various conflicting private and public interests affected by the state action must be analyzed and balanced, and the risk of erroneous deprivation of a protested interest must be evaluated, given the procedure under scrutiny. Matthews v. Aldridge, 424 U.S. 319, 96 S.It. 893, 47 led to D18, 1976. The U.S. Supreme Court has dealt with the post-judgment seizure question on 2 occasions. In Endicott, Johnson v. Encyclopedia Press, Incorporated, 266 U.S. 285, 1924, and Griffin v. Griffin, 327 U.S. 220, 1946. The court addressed the issue of whether notice and hearing must be provided before post-judgment remedies may be applied. Endicott dealt with wage garnishment. Griffin involved an out-of-state support judgment and the procedure for obtaining a writ of execution in the second state. Although the two cases involved identical constitutional issues, the results were inconsistent. Endicott held that the judgment debtor is not entitled to pre-seizure notice and hearing, while Griffin held that notice and hearing are required. In Endicott, the court rejected the due process complaint, stating, "The established rules of our system of jurisprudence do not require that a defendant who has been granted an opportunity to be heard and has had his day in court, should, after a judgment has been rendered against him, have a further notice and hearing before supplemental proceedings are taken to reach his property in satisfaction of the judgment." Endicott has never been overruled, despite the existence of Griffin, and continues to provide authority for execution to satisfy judgment debts, as evidenced by numerous appellate decisions. Huggins v. Dienhard, 654 P2D 32, Arizona. App. 1982, Casa del Rey. v. Hart, 643 P2D 900, Wash. 1982, Jedian v. Jedian, 630 P2D 579, Cullo. 1979, Hartford Elec Light Company v. Tucker, 438 A2D 828, Connecticut. 1981, Mitchell v. Mitchell, 611 P2D 373, Utah. 1980, Black v. Black, 377 A2D 1308, RI. 1977, Sanchez v. Carath, 568 P2D 1078, Arizona. App. 1977, In Remarriage of Cruikshanks, 116 calories. RPTR. 10, Cal.app. 1974, Bittner v. Butts, 514 SW2D 566, Mo. 1974, Halpin v. Austin, 385 F.Sup. 1009, N.D. George. 1974, Langford v. Tennessee, 356 F.Sup. 1163, W.D. Tennessee. 1973, Moore v. DeBarker, 286 F.Sup. 1163, DNM. 1968. Curiously, despite the strength of the cited case law, Endicott has not established a firm rule. In Griffin, the Supreme Court rejected the Endicott rationale without expressly overruling the prior decision. Under the terms of a 1924 New York divorce decree, the husband was ordered to make monthly support payments of $250. The husband failed to comply and the wife obtained judgment after notice and hearing. In 1936, she obtained the docketing of a second judgment, this time without notice to the husband. The wife then attempted to enforce the second judgment in the District of Columbia. The Supreme Court held that it would be a violation of the husband's right to due process to allow enforcement of the judgment in the District of Columbia because of the lack of notice and hearing before the order was reduced to judgment in New York. The husband was prevented thereby from raising any defenses he might have possessed, which included filing a motion for retroactive modification or proving payment or satisfaction. The court concluded that additional due process was required because enforcement proceedings affected his rights in ways in which the 1926 decree did not. 327 U.S. at 229. Another trend is important. Beginning in 1969, the Supreme Court struck down a number of prejudgment garnishment statutes that did not provide for pre-seizure notice and hearing. See Sneadash v. Family Finance Corporation, 395 U.S. 337, 89 S.E.T. 1820, 23 Led 2D 349, 1969, Fuentes v. Chevin, 407 U.S. 67, 92 S.E.T. 1983. 32 Led 2D 556, 1972, Mitchell v. W.T. Grant, 416 U.S. 600, 94 S.E.T. 1895, 40 led 2D 406, 1974, North Georgia. Finishing, Incorporated v. Deachem, Incorporated, 419 U.S. 601, 95 SET 719, 42 led 2D 751, 1975. These cases, combined with Griffin, recently have produced a number of decisions striking down post-judgment garnishments and executions where the procedure used did not provide for pre-seizure notice and hearing. See Deary v. Guardian Loan Co., 534 F.Sup. 1178, SDNY 1982, Finberg v. Sullivan, 634 F2D 50, C.A.3 1980, Betts v. Tom, 431 F.Sup. 1369, D. Hawaii 1977, Brown v. Liberty Loan Corporation, 392 F.Sup. 1023, M.D. Fla. 1974. J. These decisions typically have referred to Griffin and Matthews v. Aldridge, Supra, and have noted the proliferation of exemption rights that have been established in recent years to insulate debtors' property from execution. The decisions have held that pre-seizure notice and hearing are necessary to lessen the risk that a judgment debtor will be unable to assert his or her exemption rights. It is virtually impossible to reconcile these two lines of case law, and it is doubtful that such a reconciliation will come from the Supreme Court in the near future. At least 4 times since 1969, the Supreme Court has refused to overrule Endicott. See in Remarriage of Cruikshanks, Supra, Mova v. DeBarker, Supra, Hannon v. DeMarcus, 390 U.S. 736, 1968, Elkin v. Elkin, U.S., 1985. The issue of when the judgment debtor must be provided a hearing is similarly unsettled. Even in pre-judgment cases, the Supreme Court has indicated that a pre-deprivation hearing may not be necessary as long as safeguards are built into the process to ensure that the creditor's claim is valid, and that an immediate post-seizure hearing be provided for. Mitchell, Supra, p. 615, 616, Deachem, Supra, p. 722, 723, such safeguards generally are built into post-judgment garnishment processes as applied to child support enforcement, in that a hearing was held at the time the order was established. The payments are paid through the court or other public registry. A post-seizure hearing is available while the garnishee is still in possession of the obligor's property. Garnishing wages. In child support enforcement, the mandatory wage withholding procedure will replace wage garnishment in all but a few circumstances. Garnishment may continue to be useful when the family is no longer receiving child support enforcement services and an arrearage is due and owing to the state. The state's garnishment procedure is quick and easy. The garnishment could be used to collect support while the notice and hearing procedure of the wage withholding statute is being complied with. In addition, much of the statutory and case law regarding wage garnishment will continue to apply in serving and enforcing income withholding orders under the new procedure. This discussion will focus on 2 such topics: 1. The percentage of an obligor's disposable earnings that is subject to garnishment, and 2. The person who is authorized to accept service of a wage garnishment on behalf of an employer. The FPA restricts the amount of an individual's disposable earnings that can be garnished to enforce a support obligation. Prior to 1977, when the Tax Reduction and Simplification Act was passed, there were no federal imitations, and many states allowed 100% of an obligor's wages to be garnished. 15 U.S.C. 1673b now provides that the maximum amount of an individual's disposable earnings that may be garnished for support is as follows: 50% if the individual is supporting his or her spouse, or a dependent child. 60% if the individual is not supporting any such additional persons. These percentages increase to 55 and 65%, respectively. if the garnishment is issued to collect support payments that fell due more than weeks earlier. The FPO does not preempt the law of garnishment entirely. These percentages represent the maximum that state law may allow to be garnished. Where state and federal law conflict, the law that provides the debtor with the greatest protection applies. In addition to the percentage limitations, the FPO prohibits an employer from discharging an employee as a result of a garnishment for only one indebtedness. An annotation of federal and state case law construing the FPO appears at 14 ALR Fed 447. Garnishing out-of-state wages. It is often possible to garnish wages earned outside the state in which the children reside, as long as an order exists in that state, or can be registered in that state. The court that entered the order had personal jurisdiction over the absent parent and subject matter jurisdiction over the cause of action that produced the order, and the court has jurisdiction over the employer. It is well settled that a foreign corporation authorized to do business in a state and subject to process therein may be garnished on a debt owing to a non-resident of the state. Champion and Turn. Corp. v. Ars. 587 F. Sup. 1274, D. Connecticut 1984, quoting Mechanics Finance Company v. Austin, 8 NJ 577, 86 A2D 417, 1952, Garrett v. Garrett, 30 Cullo. App. 167, 490 P2D 313, 1971, Little v. Little, 34 N.J. Super. 111, 111 A2D 517, 1954, Burl v. Burl, 48 Del.Go. 387, 24 Pascals. D. and C. 412, par.super.ct. 1961, but C. Morrill v. Tong. 45 NE2D 1221, Mass. 1983. In the Rs case, the U.S. District Court for Connecticut specifically rejected the absent parent's argument that the enforcing court must have physical power, jurisdiction, over the administrative branch of the corporation that will be responsible for carrying out the terms of the garnishment order. The court held that a corporation is a single person and rejected the absent parent's argument on public policy grounds. Service of process. One lesson child support enforcement attorneys have learned from using garnishment as an enforcement remedy is the crucial importance of instructing the sheriff, or other process server, to serve the correct individual. Typically, garnishment statutes require personal service on individuals and partnerships, with respect to corporate garnishees, as follows. Notice of garnishment shall be served on a corporation, in writing, by delivering such notice, or a copy thereof, to the President, Secretary, Treasurer, Cashier, or other chief or managing officer of such corporation, provided, such notice may be served on a railroad corporation by delivering the same, or a copy thereof, to any station or freight agent of such corporation, and on insurance companies not incorporated by or organized under the laws of this state, by delivering the same, or a copy thereof, to the Superintendent of the Insurance Department. Section 525.030 Rsmo 1978. In addition, many state statutes governing corporations include a provision which requires all corporations doing business within the state to appoint a registered agent to accept service of process on behalf of the corporation. The registered agent, or corporate officer, can be identified by contacting the state agency that maintains the records required by the corporation's statute, usually the Secretary of State. Again, because garnishment is a creature of statute, strict compliance with all statutory requirements is essential. Anything short of full compliance will fail to confer upon the court the necessary jurisdiction over the garnishee. 6 am.j.2d, Attachment and Garnishment, Seconds. 339. There is much case law regarding the definition of general or managing agent for purposes of accepting process on behalf of a corporation. Missouri courts have construed the above statute to define valid service as service on an officer or a duly constituted executive officer whose authority and powers are such that he is regularly in control of the operations and business of the corporation. Smith v. Bennett, 472 SW2D 623, Mo.app. 1971, C. Anno, 17 L3D 625. The case law may not clarify the definition of managing or general agent sufficiently to allow the 4D attorney to choose an individual for service. Especially with respect to large employers, the sheriff's office often can identify an individual who has accepted service on behalf of an employer in the past. If not, it may be prudent to consult the records maintained by the Secretary of State in lieu of serving an unidentified payroll officer or manager. Garnishing bank accounts. Bank accounts can be very good collection sources. 3 issues regarding the garnishment of bank accounts can cause problems, however. 1. Discovering the existence and identifying of the account. 2. Discovering which branch of a bank may accept service of process to affect the account. And 3. If the absent parent has remarried or has a joint account with another individual such as a business partner, determining if the account is subject to garnishment for enforcement of the absent parent's obligation. Finding the existence of a bank account used to be a difficult task because the account had to be discovered without alerting the absent parent that the search was taking place. However, the Office of Child Support Enforcement has developed a system for locating absent parents using Tax Form 1099, with which banks report interest earned on bank accounts. Although information gathered this way is intended primarily for parent location and must be verified, pursuant to 26 U.S.C. 6103 before it can be used for any purpose, the method has proved to be very useful. In addition, state 4D agencies have developed methods of discovering their existence. Often, the custodial parent, or the children, if visitation is occurring, will know where the absent parent. Banks, landlords, mortgagees, and credit reporting agencies can be sources of information as well. Some jurisdictions accept personal checks for child support payments and then keep a record of the account number and location. Once a lead is obtained, it is often possible to confirm the existence of the account over the telephone. This practice is developed in some areas to allow potential lenders to confirm the existence of an account prior to extending credit and to allow merchants to confirm the existence of the account prior to accepting a check. Unfortunately, discovering the existence of the account is not the 4D agency's last problem. With the increase in branch banking, it is not unusual for a bank to have branches in many different locations. According to the annotation at 12 Al 3D 1088, a general rule is emerging which holds that each branch of a bank is a separate entity, in no way concerned with accounts maintained by depositors in other branches or at the Home Office. Cronin v. Schilling, 100 NIS 2D 474, Sup. 1970. Accordingly, accounts may be garnished only by serving the writ at the bank location that is holding the funds for the depositor. One very old case establishes a contrary rule in Illinois, Bank of Montreal v. Clark, 108-1.app. 163, 1908. Due to the advent of automatic teller machines, many depositors now may withdraw their funds on deposit at all branches of the bank. This development may produce a change in the general rule. Either way, now that the banking community is highly computerized, it generally will be possible to obtain the location of the account by contacting the main office. Once done, it is possible to serve the appropriate officer at the branch where the account was created. Once the garnishment has been issued and served, the most troublesome problem concerns interests held in the account by third parties. Generally, creditors can garnish a joint bank account to enforce judgment debts owed by one of the depositors. See Anno, 11 Al 3D 1465, but cf. Comstock v. Morgan Park Trust and Savings Bank, 319-3 App. 253, 48 NE 2D 980, 1943, and Andre v. Equitable Trust Co., 428 2D 1263, 1980, where this is the rule. Courts are split as to whether the entire account is subject to garnishment. Park Enterprises, Incorporated v. Trask, 233 Minnesota. 467, 47 NW2D 194, 1951, or whether only the judgment debtor's interest in the account is reachable. United States v. Nat. Bank of Commerce, 554 F.Sup. 110, E.D.Uc, 1982, Perma v. Sark, 224 Can. 642, 585 P2D 991, 1978, Newman v. First Nat. Bank, 420 SW2D 20, Mo.App. 1968, Beehive State Bank v. Rosquist, 21 Utah 2D 17, 439 P2D 468, Utah 1968, in states that recognize the concept of tenancy by the entireties. Many courts have concluded that when a debtor opens an account with his spouse, in child support situations, the second wife, the entire account is protected from garnishment, except to collect joint debts. Garnishment against federal employees. Pursuant to 42 U.S.C. 659, monies due from or payable by the United States as remuneration for employment to any individual, including members of the armed services, is subject to garnishment in like manner and to the same extent as if the United States were a private person. This waiver of sovereign immunity is limited to garnishments to enforce an obligor, employee's legal obligation to provide child support or make alimony payments. PL 95-30 amended 42 U.S.C. 659 to define valid service of process in such garnishment proceedings. This remedy is available whether or not the children are receiving AFDC benefits. See Anno 44 AL Fed 494. The waiver of sovereign immunity does not confer jurisdiction upon the federal court to issue writs of garnishment upon the federal government. Kelly v. Kelly, 425 F.Sup. 181, W.D.La. 1976, Overman v. United States, 563 F2D 1287, C.A.8 1977, nor does the federal statute create a garnishment remedy in states that do not have such a procedure. The writ of garnishment must issue pursuant to existing state procedure and must emanate from the state court that rendered the order to be enforced. See Morrison v. Morrison, 408 F.Sup. 315, N.D.Tex. 1976, Popple v. United States, 416 F.Sup. 1227, WDNY 1976, US v. Morton, 104 S.Ct. 2769, 1984. Service of the writ is accomplished pursuant to 42 U.S.C. 659, as follows. Service of legal process brought in for the enforcement of individual's obligation to provide child support or make alimony payments shall be accomplished by certified or registered mail, return receipt requested, or by personal service, upon the appropriate agent designated for receipt of such service of process pursuant to regulations promulgated pursuant to Section 416, or, if no agent has been designated for the governmental entity having payment responsibility for the monies involved, then upon the head of such governmental entity, such process shall be accompanied by sufficient data to permit prompt identification of the individual and the monies involved. 42 U.S.C. 659. The Office of Personnel Management has published regulations at 5 CFR 581, including a listing of agents designated to accept legal process. 5 CFR 581, App. A. Under 42 U.S.C. 659a, only monies to be paid to the obligor as remuneration of employment are subject to garnishment. Several cases have held that this definition includes military retirement pay. Watson v. Watson, 424 F.Sup. 866. EDNC 1976, Crane v. Crane, 417 F.Sup. 38, ED Oklahoma. 1976. Conversely, Veterans' disability benefits being paid to a veteran who waived all rights to military retirement pay are not garnishable. Sanchez Dieper v. Rodriguez Pereira, 580 F. Sup. 735. D.C. Puerto Rico 1984. Related attorneys' fees are recoverable to the extent that they are entitled to judgment status in the state. Garrett v. Hoffman, 441 F. Sup. 1151, ed. par. 1977, Murray v. Murray, 558 F2D 1340, C.A.8 Mo. 1977, 42 U.S.C. 662. Garnishing workers' compensation benefits. Workers' compensation statutes spread the financial risk that workers face each day on the job. They mandate that a form of insurance be provided to each worker involved in a covered activity, to compensate the worker for the financial cost of injuries sustained on the job. To this end, virtually all workers' compensation statutes protect personal injury awards by exempting them from seizure by the workers' creditors. These exemptions have been construed liberally by the courts as applied to the claims of general creditors. 31 Al 3D 532, 535. However, the courts have been willing to limit the exemption's application to child support, alimony, and governmental claims. Recent cases have held that workers' compensation awards may be garnished to enforce child support orders. These decisions have noted that a child support obligation is not a debt as the term was used in the exemption statute, and that allowing the garnishment would be consistent with the legislature's intent in enacting the exemption, to allow the injured worker to support his dependents in addition to himself. D'Alessandro v. D'Alessandro, 110 Miscellaneous 2D 342, 442 NIS 2D 400, 1981. American Mutual Life Insurance Company v. Hicks, 159 GA.app. 214, 283 SC 2D 18, 1981. Stella v. Stella, 97 NJ Super 493, 235 A2D 476, 1967, and Petrie v. Petrie, 41 Michigan. App. 80, 199 NW2D 673, 1981. There is contrary authority as well, including Satterfield v. Satterfield, 292 or 780. 643 P2D 336, 1981, and Bruce v. Bruce, 100 Ohio App. 121, 130 NE2D 433, 1955. Once the exemption problem is overcome, the 4D attorney must determine whom to serve with the garnishment and when to serve it. Generally, the workers' compensation insurance will be underwritten by an out-of-state insurance company, the identity of which can be obtained through the worker's employer. Insurance companies generally may be served through their registered agent, as defined above, or through a state official, such as the director of the insurance regulatory agency. In some situations, it also may be possible to serve the worker's attorney with a garnishment. 35 Al 3D 1094. Determining when to serve the garnishment can be a difficult decision, at least in states where garnishments are effective for short time periods. If the claim has yet to be settled and state law allows for consecutive garnishments, the best choice is to serve the insurance company immediately, and reissue garnishments as often as necessary to achieve an unbroken chain of weeks or months. In some states, such as Kansas, garnishment is effective only as to debts owed by the garnishee to the judgment debtor at the moment in time the garnishment is served. In these states, it might be more effective to use a wage withholding statute, assuming the definition of wages is broad enough to encompass workers' compensation benefits, or to seek an equitable lien by asking the court to invoke its equity power to assist in enforcement of the order. Civil contempt. A court has inherent authority to punish individuals for violating its valid judgments or decrees, and that authority has been recognized since the dawn of judicial antiquity. Zettinger v. Mitchell, 244 SW2D 91, Mo.app. 1951, Any act or omission that embarrasses the court, lessens its authority or dignity, or obstructs the administration of justice constitutes contempt. Contempt is classified as either civil or criminal. No clear line distinguishes civil from criminal contempt. However, civil contempt differs from criminal contempt in both purpose and procedure. If the purpose and character of the penalty imposed by the court is remedial and for the benefit of a private party to the action, the contempt is classified as civil. However, if the purpose of the penalty is to vindicate the authority of the court, the contempt is classified as criminal. See Gompers v. Buck-Stovko, 211 U.S. 324, 1911. In Re Grand Jury Investigation, 600 F2D 420, 3D Sir. 1979, Commonwealth v. Feek, 439 A2D 774, Par. Super. 1982, United States v. North, 621 F2D 1255, 3D Sir. 1980, in Re Timmons, 607 F2D 120, 5th Sir. 1979. This section discusses civil contempt, including the following subtopics: procedure, notice and hearing requirements of due process, the indigent contemner's possible right to representation by counsel at state expense, elements of contempt, burden of proof and purgation requirements, and commitment procedure. The following section treats criminal contempt procedure. In most jurisdictions, the contempt process is initiated by filing a motion for order to show cause as a supplementary proceeding in the cause of action which produce the underlying support order. The motion is heard and ruled on by the court ex parte. In virtually all jurisdictions, the judge grants the motion and issues the order to show cause without even an informal hearing. Most courts require the motion to be supported by an affidavit from the payee or a certified copy of the clerk's payment record if the order is payable through the court for the period in question. After the judge reviews and signs the order to show cause, it is processed by the court clerk's office. The clerk will check the court calendar for an available date, prepare an appropriate summons to accompany the order, and forward the two documents to the appropriate sheriff's, or other process servers, office for service on the absent parent. See Exhibits 6.6 and 6.7. Notice requirements. In the case of Vinri Oliver, 333 U.S. 257, 275, 68 SET 499, 92 Led 2D 682, 1948. The U.S. Supreme Court held that due process requires that an individual charged with contempt of court be advised of the charges against him, have a reasonable opportunity to meet them by way of defense or explanation, have the right to be represented by counsel, and have a chance to testify and call other witnesses in his behalf. The obligor generally must have actual notice of the date and time of the hearing on the order to show cause. If it can be established that the obligor is avoiding service of process, it is sometimes possible to serve the obligor's attorney of record, assuming the attorney-client relationship is intact, or to serve an adult at the obligor's residence. See in Re Morally, 11 California App. 3D 819, 839, 1970. In order to direct such service, it may be necessary to file an accompanying motion asking the court for permission prior to issuance of the summons. It also might be possible to direct the sheriff to attempt substituted service on a routine basis if personal service proves difficult. If the obligor appears at the hearing in response to the summons, actual notice will have been given and the issue will not have to be addressed. If he or she does not show up, it may be possible to justify the substituted service to the court as a step in obtaining a bench warrant. In addition to the issue of getting the summons and order served on the obligor, there is an important issue surrounding the quality of the notice. The allegation contained in the motion for order to show cause and the language transferred to the order itself must be specific enough to allow the obligor to prepare a defense at the show cause hearing. The specificity that will be required will vary from state to state, and even from case to case. Generally, it is prudent to allege the specific provisions of the support order, and set forth the obligor's payment record during the applicable period. Serving a copy of the motion for order to show cause with the supporting affidavit or court record is one possible way to meet this requirement. Bench warrants. In most states, A bench warrant may be issued directing the sheriff to arrest an obliger who is served with an order to show cause but who fails to appear at the hearing. See cal.cif.proc. Code Section 1212. The procedure after the obliger is apprehended varies from court to court. If the judge is available, many courts will notify the attorneys that the obliger has been brought in on the bench warrant, and a hearing on the order to show cause will commence as soon as counsel can convene. When the judge who will hear the show cause hearing is not available, another judge will hold a preliminary hearing for the purpose of setting bail to secure the obliger's appearance at the show cause hearing. Some courts routinely follow the latter procedure, even when the appropriate judge is available. Right to counsel. As noted above, due process requires that the obliger be given the opportunity to be represented by counsel at the show cause hearing. This requirement has produced quite a bit of case law with respect to indigent obligers who ask for, and who are denied, counsel at state or county expense. The decisions are split on this issue. Generally, an indigent defendant possesses the right to court-appointed counsel only where a proceeding might result in deprivation of his or her liberty. Lasseter v. Department of Social Services, 452 U.S. 18, 1981. Since imprisonment is a frequent outcome of the show cause hearing, some courts have held that counsel must always be provided to indigent contemners. Other courts take a middle position, holding that the right to counsel does not accrue until the court determines that imprisonment is a possible outcome. Here, the trial court must make two findings prior to appointing counsel. 1. The contemner is indigent and, 2. The elements of contempt have been duly alleged by obligee's counsel. The third position is that, in civil contempt cases, by definition, the obliger will be imprisoned only if he or she has the present ability to purge himself of the contempt. If the obliger has that present ability, he or she is not indigent and does not need court-appointed counsel. Elements of contempt. 5 elements must be established to support a finding of contempt in a civil proceeding: continuing personal and subject matter jurisdiction in the court that is holding the show cause hearing, existence of a valid and exact support order, knowledge of the order by the obliger, ability of the obliger to comply, willful non-compliance by the obliger. See Jafarian-Kerman v. Jafarian-Kerman, 424 SW2D 333, 341, Mo.App. 1967. Gonzalez v. District Court in and for Otero County, 629 P2D 1074, Colorado 1981. Burden of proof. The moving party in a civil contempt proceeding normally is required only to establish a prima facie case by proving entry of the order, actual or constructive knowledge in the obliger, and the obliger's non-compliance. Dyer v. Dyer, 92 Arizona 49. 373 P2D 360, 1962, Sfug v. Sfug, 16 or.App. 151, 517 P2D 1073, 1974, in remarriage of Vinit, 544 SW2D 236, 246, Mo.App. 1976. Once the moving party overcomes this initial hurdle, the burden shifts to the obliger to show facts which will excuse his non-compliance. If the defense's inability to pay, he or she has the burden of proving that it was genuine and not occasioned by his or her own acts. Brooks v. Brooks, 286 SE2D 669, SC 1982, ex parte Amendas, 621 SW2D 664, text.cif.app. 1981, Hess v. Hess, 87-3. App.3D 947, 409 NE2D 497, 1980, Blair v. Blair, 600 SW2D 143, Mo.App. 1980, Parker v. Parker, 97 Idaho 209, 541 P2D 1177, 1975, Stafford v. Stafford, 27 Miscellaneous.2D9, 203 NIS 2D 935, 1960, State Ex Rel. Blackwell v. Blackwell, 179 P2D 278, 181 or 157, 1947, Vinit, Supra, p. 245, 53 Alt 2D 591, Chapter 7, Infra. Few appellate courts have analyzed the type of evidence an obligor would have to submit to the court to make a defense of inability to pay. One excellent analysis appears in the case of Ex parte Hennig, 559 SW2D 401, text.sif.app. 1977, as follows. In order to establish the inability to pay, the relator must show not only that he lacks the financial resources to pay the delinquency, but also that he knows of no other source from which the sum might be obtained. This ultimate fact can be established by proof of the following. 1. That the relator lacks sufficient personal or real property which could be sold or mortgaged to raise the needed sum, and 2. That the relator has unsuccessfully attempted to borrow the sum from financial institutions such as banks, credit unions, and loan companies, and 3. That the relator knows of no other source, including relatives, from whom the sum could be borrowed or otherwise secured. Citation omitted. Of course, these are only conclusory elements which must be supported by specific evidence according to the facts of each particular case. When the obligor presents evidence that the non-compliance was financially justified, some states require the moving party to present evidence to the contrary. Thomas v. Thomas, 406 SO2D 939, Alabama 1981, Henderson v. Henderson, 55 N.C.App. 506, 286 SE2D 657, 1982. The existence of the valid support order can be established by asking the court to take judicial notice of the support order contained in the court file. Ex parte Amen, 19 P 380, 77 California 198, 1888, State Ex Rel. Cook v. Cook, 64 Northeast 567, 66 Ohio Street 566, 53 Alt 2D 597, 1902, but see People in the Interest of FSB, 640 P2D 268, Cullo. App. 1981. The obligor's knowledge of the order usually can be established by reference to the support order itself, which often will note the presence of the obligor or his or her attorney at the hearing that produced the order. If the order does not contain such a reference, the court file should contain the court clerk's certificate of mailing, which creates a rebuttable presumption of service. Jones v. Jones, 91 Idaho 578, 428 P2D 497, 1967. In some states, such as California, it is customary to serve the obligor in person, if necessary. Personal service creates a presumption as well. Cal.sif.proc. Code Section 1209.5, non-payment can be established by entering the court clerk's payment record into evidence, if available. If not, it might be necessary to call the obligee, or a representative from the 4D agency, to testify as to the obligor's non-compliance. It also might be possible to substitute an affidavit in lieu of live testimony. Bowden v. Bowden, 198 Tennessee. 143, 278 SW2D 670, 1955, Catron v. Catron, 577 P2D 322, Cullo. App. 1978. When a dispute arises as to whether payments were or were not made as ordered, the obligor generally must plead satisfaction as an affirmative defense and prove the defense by substantial evidence. Huchtman v. Huchtman, 557 P2D 427, Oklahoma. 1976. Carleskint v. Carleskint, 575 SW2D 845, Mo.app. 1978, State Ex Rel. Fry v. Fry, 559 P2D 1293, 28 or.app. 403, 1977, 53 Alt 2D 591, This rule is justified because the evidence of payment is usually in the sole possession of the obligor. Placing the burden on the obligee on this issue would force him or her to prove a negative. Punishment for civil contempt must be remedial and coercive. As such, the purpose of the punishment is not punishment per se, nor is it to protect, preserve, and vindicate the authority of the court and the power of the law. Criminal contempt proceedings, discussed below, further these purposes. Because punishment in civil contempt proceedings must be remedial and coercive, any imprisonment or fine is improper unless its purpose is to benefit the obligee and it allows the obligor to purge himself or herself by complying with clearly stated and attainable requirements. The obligor must have a present ability to comply with those requirements. Gompers v. Buckstove Supra, in Remarriage of Hart, 603 P2D 970, Cullo. App. 1979, in Remarriage of Crowley, 663 P2D 267, Cullo. App. 1983, Kramer v. Kelly, 401 A2D 799, Par.Super. 1979, Long v. Long, 421 A2D 822, Par.Super. 1980, Illica v. Illica, 295 NW2D 268, Nebraska. 1980, Bonder v. Bonder, 438 So2D 541, Fla.Dis.ct.app. 1983, Walker v. Walker, 375 NE2D 1258, Ohio. 1978, Smith v. Smith, 451 So2D 945, Fla. 1984, Rutherford v. Rutherford, 296 MD. 347, 464 A2D 228, MD.ct.app. 1983. A few courts have held that imprisonment is proper in civil contempt when the obligor intentionally or willfully placed him or herself in a financial condition that makes compliance impossible. State ex rel. Stanhope v. Pratt, 536 SW2D 567, 575, Mo. 1976, Ziegler v. Butler, 410 So2D 93, Alabama.Cif. App. 1982. These cases are difficult to reconcile with the three limitations set forth above, unless the court fashions its purgation requirements to allow the obligor to purge himself or herself by something other than payment. Otherwise, the obligor would not carry the keys to the jailhouse in his own pocket. Punishment in civil contempt proceedings tends to fall into three categories: 1. Incarceration, 2. Coercive fines, and 3. Compensatory fines. Doyle v. London Guarantee and Co. 204 U.S. 599, 27 S.It. 313, 51 Letter 641, 1907, United States v. United Mine Workers of America, 330 U.S. 258, 67 S.It. 667, 91 Led 884, 1946. While all three are conceptually appropriate to enforce child support orders, most courts rely on incarceration alone. Generally, the fine or imprisonment continues until the obligor complies with the court's purgation requirements. Because this type of punishment conceivably could be a life sentence, many courts routinely place a maximum on the punishment by sentencing the obligor to a fixed term that the obligor can end at any time by complying with the purgation requirements. Such a practice has been upheld in at least one appellate decision. Johnson v. Johnson, 319 P2D 1107, 1111, Oklahoma. 1957. A fixed term without possibility of purgation is clearly not proper. Hess v. Hess, 43 December 882, 409 NE2D 497, 3 App. 1980. Purgation requirements and commitment. The purgation requirements must be set forth in the judgment and commitment order in clear language and detail such that the obligor knows precisely what must be done in order to avoid the punishment. Otherwise, the judgment and commitment are void, and the obligor must be released. In Requivido, 611 SW2D 711, text.sif.app. 1981. Vokolek v. Carnes, 512 SW2D 112, Mo. 1974. Within these limits, the court's discretion in tailoring the purgation requirements to fit the case at hand is very broad. The U.S. Supreme Court has ruled that the measure of the court's power in civil contempt proceedings is determined by the requirements of full remedial relief. Macomb v. Jacksonville Paper Co. 336 U.S. 187, 93 led 599, 605, 1948. See also Hop v. Hop, 156 NW2D 212, 216, Minnesota 1968, 85 Al 3D 897. Civil contempt is an equitable remedy. Therefore, the court has full equitable power to order the obligor to carry out any act that he or she has the present ability to perform. If the contemner has the ability to borrow from friends and relatives, the court can require that the obligor do so in order to purge. Ex parte Hennig, supra. If the obligor has the ability to sell or mortgage property in order to make an arrearage or current support payment, the court may require him or her to do so, even though the property involved would be exempt from execution. KCV. KC. 175 or 328, 153 P2D 700, 1944, Sheridan v. Sheridan, 33 calories.app.3D 995, 109 calories.rptr. 466, 1972, Johnson v. Johnson, 413 A2D 1115, par.super. 1979. The court even may require the obligor to make a direct transfer of personal property. In Remarriage of Thompson, 96 calories.app.3D 621, 158 calories.rptr. 160, 4th dist. 1979. Where the obligor is unemployed, the court may include a sequel order in the purgation requirement and require the obligor to report periodically to the court any efforts to find employment. Dennis v. Wisconsin, 117 Wis.2D 249, 329 NW2D 272, 1984. Many states allow for a commitment order, which requires the obligor to spend nights and weekends in jail, but which allows him or her to be released each day to go to work. Hopkinson v. Hopkinson, 478 2D 981, par. 1984. Many courts will allow the obligor a short time period to accomplish the purgation requirement prior to invoking the commitment order. For instance, a court's judgment and order might read, obligor found in contempt of this court for failure to make X payments on X dates. Obligor found to have had the ability to make payments as they fell due, obligor found to have an interest in certain, real or personal, property upon which he may borrow such sums as are necessary to comply with the order of this court. Obligor adjudged in contempt and committed to the county jail until such time as she pays $X to the clerk of court. Execution of commitment suspended until X date to allow obligor to obtain the funds necessary to comply with this order and judgment. Judges like to use orders such as this one because they recognize that it is the threat of jailing more than the jailing itself that provides the incentive to pay. By allowing the obligor a period of time to comply with the purgation conditions, the end can be attained without the need for the obligor to serve time. The obligor does not risk losing his or her job. The county does not have to incur the cost of housing a prisoner, and the obligor's task in raising the money is logistically easier. This technique has caused some problems, however. If the order contains the wrong language, the commitment is tenuous. In Meyer v. Meyer, 532 SW2D 54, 60, Tennessee.app. 1975, a Tennessee appellate court overturned a contempt judgment that contained a suspended sentence, holding that no such thing exists. In Gross v. Gross, 557 SW2D 448, 453, Mo.App. 1977, and in Refund 544 SW2D 236, 247, Mo.App. 1976, Missouri appellate courts held that probation and civil contempt are conceptually incompatible, and any contempt judgment providing for imprisonment and probation conditioned on compliance is void. See Exhibits 6.8 and 6.9. Another problem with delayed enforcement is procedural. When the date set in the contempt judgment passes prior to execution of the commitment order by the sheriff, the obligor may have a right to another hearing on the issue of whether he or she has complied with the purgation requirements. Green v. District Court of Polk County, 342 NW2D 818, 1983. If this is true, then the initial hearing on the show cause order is essentially useless. Civil contempt is an effective remedy only where the obligor can be brought before the judge immediately after a payment is missed, and only if the judge is willing to back up the support order with jailing or fine. If caseload pressures keep non-complying obligors out of court, or if the judge is unwilling to incarcerate obligors who are able to pay, then contempt proceedings can actually be counterproductive. The same is true for specific cases where the obligor is destitute and an appropriate equitable remedy does not present itself. Unless the court can impose a sanction, the obligor's experience in the contempt process merely teaches him or her that the court spark is worse than its spite. In states which allow retroactive modifications, a contempt proceeding brought before a weak or powerless judge merely allows the obligor an opportunity to file a counter-motion for a downward modification. Clearly, civil contempt should be only a last resort, and only for cases that exhibit favorable facts. Criminal contempt. A few states use criminal contempt to enforce child support obligations. The use of criminal over civil contempt can be imposed by statute, for example, cal.cif.proc. Sections 1209, 1209.5, or the practice can evolve naturally. Criminal contempt protects, preserves, and vindicates the authority of the courts as society's final arbiter of disputes. Tifi v. Tifi, 533 SW2D 563, 566, Mo. Bank 1976, Kramer v. Kelly, Supra, Crowley v. Crowley, 663 P2D 267, Cullo. App. 1983. Gibson v. Gibson, 15 calories. App. 943, 948, 1971. The distinction is crucial. While the same act might give rise to both civil and criminal contempt charges, each confers distinct procedural rights. A strictly penal sanction may be imposed only where the defendant is provided the essential procedural protections required by due process. Kramer, Supra, Murray v. Murray, 587 P2D 1220, Hawaii, 1978, Sword v. Sword, 59 Michigan. App. 730. 229 NW2D 907, 1975. These rights may include notice of the charges as in criminal cases, in re Hinman, 239 calories. App. 2D 845, 1966. Appointed counsel, after an indigency hearing, Sword, Supra, a jury trial, Sword, Supra, but see in re Morally, 11 calories. App. 3D 819, 1970, Freedom from Default Judgment, Ex parte Johnson, 669 SW2D 869, Text. App. 1984, a verdict of innocent unless guilt found beyond a reasonable doubt, Quizada v. Superior Court, 171 calories. App. 2D 528. 1959, Protection from Self-Incrimination, Ex parte Gould, 990 calories. .360, 1983, Oliver v. Superior Court, 197 App.2D 197, 1961, Sword, Supera. Burden proof on prosecution, Masonite Corporation v. International Woodworkers of America, 206 So2D 171, Miss. 1968, but see Skinner v. Rui, 351 NW2D 182, Lower 1984, trial before an impartial judge, that is, one who is not familiar with the facts of the case. Sword, Supera, in remarriage of Nayswinger, 467 NE2D 43, Indiana. App. 1984. Proof of contempt by independent evidence, that is, extrajudicial statements of the obligor cannot be introduced until all elements of contempt are otherwise proven. People v. Wong, 35 App.3D 812, 1973. Clearly, a criminal contempt proceeding is considerably more complicated than a civil contempt proceeding. The initiation of the proceeding may require a more formal notice than is provided the civil contemner in the motion and order to show cause, although a formal information or indictment is not necessary. The possibility of an indigency hearing, a jury trial, and a change of judge makes the process potentially a very long one. The evidentiary hurdles are difficult to overcome without knowledgeable witnesses. Despite these drawbacks, there are occasions when criminal contempt is useful. Where an absent parent has been charged with civil contempt on numerous occasions, but regularly frustrates the action by paying the arrearage on the day of the show cause hearing and never making payment voluntarily, a criminal contempt action may change his or her attitude about compliance. State Ex Rel. Fry v. Fry, 559 P2D 1293, or 1977, Tiffy, Supera, United States v. United Mine Workers of America, 330 U.S. 258, 299, 67 SET 667, 91 Led 899, 1946. Furthermore, criminal contempt may be the only available remedy to punish an obligor who has made himself or herself unable to pay by quitting a job or taking one at a much lower salary. See Murray, Supera. Criminal non-support. Most states have passed statutes making the failure to support one's children a criminal offense. In many states, the attorneys who establish and enforce child support obligations in civil court are district or prosecuting attorneys who also have discretion to file criminal charges against an absent parent when appropriate. Criminal non-support charges are appropriate in instances where civil remedies are not sufficient. Indeed, one Florida appellate court has held that criminal charges should not be used if alternate civil remedies are available. Bryan v. State, 362 So 2D 812, Fla. App. 1979. This decision is perhaps the culmination of a process. Child support enforcement has turned away from criminal-style remedies in the recent past, as a 4D administrators learned that an emphasis on summary civil remedies such as wage withholding and tax refund interceptions produced higher overall collections. Nevertheless, felony non-support proceedings can still prove useful in some instances. Where an obligor has fled the jurisdiction or is avoiding service of civil process, the filing of criminal charges will allow issuance of an arrest warrant. Once the warrant is issued, the obligor is likely to be picked up in the future, because felony warrants show up on police computers all across the country. If stopped for a minor traffic violation, the obligor will be arrested on the felony non-support warrant, and extradition is possible. Similarly, where the obligor somehow is avoiding all civil remedies, and it would be useful to change his or her attitude about the importance of voluntary compliance, a criminal non-support charge can be very effective. Pleadings. In most states, all of the normal rules of criminal procedure apply to felony non-support actions. The action is initiated by filing a criminal complaint, information, or indictment, depending on local practice. This document is presented to the judge who issues a summons or warrant. At least one old state court decision holds that if the charge is a felony or if hard labor is a possible sentence, a grand jury hearing must be held to obtain an indictment. State v. Rsmo, 121 Me. 94, 115 648, 1922. The initial pleading must allege all elements of the crime in a manner which allows the defendant to understand the charge and prepare a defense. People v. Skull. 339 3 App. 7, 88 NE2D 681, 1949. Gravett v. Commonwealth. 232 Key. 432, 23 SW2D 555, App. 1930. One issue can prove troublesome at the filing stage the location of the crime of non-support or abandonment. If both the defendant parent and the children reside in the same jurisdiction, there is no issue. Where they live in different states or judicial districts, the issue is crucial. There is case law holding that the crime occurs in the place where the children reside. There is case law holding that the crime is occurring whenever the defendant parent is at any given point in time. And there is case law holding that the action can be filed in either jurisdiction. See Anno 44 ALR 889. After accepting the complaint, the court usually issues a summons to the defendant parent, asking him or her to come to court for the arraignment. Occasionally, the court will issue a warrant for the defendant's arrest, especially if he or she has been uncooperative. At this hearing, the court will read the charge to the defendant, advise the defendant of his or her rights, determine whether the defendant requests and qualifies for appointed counsel, set a date for the preliminary hearing, and, occasionally, set bail. At the preliminary hearing, the defendant will be asked to enter a plea. If the charge is a misdemeanor, the arraignment and preliminary hearings often are combined into one proceeding. Elements. The elements of criminal abandonment or non-support vary from state to state, depending on statutory language. Typical elements of the offense are as follows: abandonment, desertion, and non-support. A culpable state of mind. Ability to provide support. The children are likely to become a public charge as a result of defendant's non-support. All states include the first two elements in the list of items that the prosecutor must allege and prove. Abandonment, desertion, and non-support are fairly straightforward concepts and have not produced much appellate case law. In Tut v. State, 310 SE2D 14, Ga.App. 1983. A Georgia appellate court held that non-support could be proved by placing into evidence the ledger card from the probation office, chronicling the defendant's non-compliance with a civil support order. The second element, culpable mental state, has produced quite a bit of case law. In states that have adopted the Model Penal Code, the standard definition of culpability applies to criminal non-support intentionally, knowingly, recklessly, or with criminal negligence. State v. Garsk. 592 P2D 1040, 39 or.App. 463, 1979. Other courts variously define the necessary state of mind as willful, bury on behalf of law v. Law, 460 NIS 2D 395, N.Y.App.Diff. 1983. Bennett v. State, 109 Text.Crim. 237, 4 SW2D 62, 10 SW2D 117, 1928. Evil intent or design, Commonwealth v. Wright, 433 A2D 511, Par.Super. 1981. Conscious object to withhold support, Boris v. State, 382 NE2D 963, Indiana App. 1978, deliberate or perverse design, malice, or an intentional or deliberate breach of duty of support, set purpose or design, Mercado v. State, 86 Tex. Crim. 559, 218 SW 491, 1920. Purposeful, Page v. State, 160 Miss. 300. 133 So 216, 1931, State v. Hayden, 224 NC 779, 32 SE2D 333, 1944, Bowen v. State, 271 P2D 739, Oklahoma. Crim. 1954. Absence of legal excuse or justification, State v. Russell, 73 Wash.2d 903, 442 P2d 988, 1968, State v. Richmond, 683 P2d 1093, Wash. 1984. Intentional, State v. Moran, 400 So 2d 1359, La. 1981. There is little agreement among the states as to how the third element is interjected into the action. In some states, ability to provide support is an element of the prosecution's case which must be proved beyond a reasonable doubt, just like the other elements. State v. Moran, Supra, Peacock v. State, 362 So 2d 174, Fladottap. 1978. In other states, inability to pay is an affirmative defense, similar to diminished responsibility or insanity in other criminal actions. Switching the burden of coming forward with the evidence on this issue usually is justified by noting that the relevant evidence is peculiarly within the defendant's knowledge. Commonwealth v. Wright, Supra, Commonwealth v. Hussey, 14 Mass. App. 1015, 441 NE2D 783, 1982, State v. Brown, 5 Ohio App.3D 220, 451 NE2D 1232, 1982, State v. Wright, 4 Ohio App.3D 291, 448 NE2D 499, 1982. At least one state Supreme Court has held that such a practice violates the defendant's right to be presumed innocent unless proven guilty. State v. Johnson, 412 So 2D 602, La. 1982, State v. Kuiper, 408 So 2D 1312, La. 1982. The fourth element is not required in all states. Crawford v. State, 166 Gadottap. 632, 305 SE2D 403, 1983. In the states where it is necessary to prove that the children were in dire straits as a result of the defendant's lack of support, various forms of proof have been approved by the courts. In Commonwealth v. Hussey, Supra, the court held that proof that the children had to turn to public assistance in order to survive was sufficient to meet the element. In Turner v. State, 343 So 2D 591, Alabama. 1977, the Alabama Supreme Court held that need, as it is used in Alabama criminal non-support statute, does not amount to destitute or necessitous circumstances. Defenses. Defendants may try to deflect the non-support charge with a number of defenses. Because of the different burden of proof and procedure in criminal cases, each defense affects the case differently than the same defense would in a civil case. Inability to pay. The definition of this defense should track the definition used in civil contempt cases, except that the measure is not necessarily the amount that should have been paid under an existing court order. Ability to pay will be judged according to the needs of the children during the period and the defendant's ability to earn. Lack of means alone will not support the defense. State v. Brown, Supra. Child living apart from obligor without obligor's consent. This defense generally has been rejected. See Benfield v. State, 4 say 869. Georgia 1888, Moore v. State, 57 say 1016, Georgia 1907, People v. Howell, 214 3 App. 372, 1919, Com. v. Donovan, 200 SW 1018, Key. 1920, State v. Sutcliffe, 25 654. RI 1892, Peel Fuss v. State, 126 NW 33, Wisconsin. 1910, Bowen v. State, 46 Northeast 708, Ohio 1897. Child supported by third party or of independent means. This is a frequent defense in states that require the prosecution to allege and prove that the children were needy due to the defendant's non-support. The defense is virtually automatic if the children were cared for by a third party, or if they or the custodial parent had independent means. A criminal charge may not be possible. Other state courts often have rejected this defense. See State v. Netzer, 3 Can.App. 673, 600 P2D 160, 1979, People v. Yates, 298 P 961, California 1931, People v. Frazier, 261 P2D 1071, California 1972. Non-paternity. Non-paternity is only properly a defense when the issue has not been decided in previous action. See Chapter 7 for a discussion of the res judicata effects of a paternity judgment. Infra, if there is no existing paternity finding and no strong presumption of paternity, paternity is an element of the prosecution's case. See Nordgren v. Mitchell, 716 F2D 1335, CA Utah 1983, People v. Askew, 33 December 777, 393 NE2D 1124, 1979, State v. Rawlings, 38 MD.App. 479, 381 A2D 708, 1978. Thus, it becomes a defense only in situations where the defendant and the mother were married and separated without obtaining a divorce, or where they obtained a divorce in which the paternity issue was not decided. Where the defense is properly interjected, the evidentiary issues should track those in a normal civil paternity case. See Chapter 10, Infra. Vagueness of the statute. Occasionally, a defendant will challenge the language in the statute that defines the offense, arguing that it is unconstitutionally vague, and that a parent is not sufficiently notified of the behavior he or she should avoid in order to be blameless. Such an argument has been upheld on occasion. See State v. Richmond, 683 P2D 1093, Wash. 1984. Gender bias in statute. Many of the existing criminal non-support statutes were enacted many years ago, when the principal or exclusive duty of support rested on the father. As a result, many of the statutes provide only that the male parent may be held criminally liable for non-support. Several courts have set aside convictions based on this gender bias. See State v. Fuller, 377 So 2D 335, 14L40H 711, La. 1979, People v. Lewis, 107 Michigan. App. 297, 309 NW2D 234, 1981. Other courts have opted to read the word father in the statute as though it says parent, to avoid the constitutional problem. See, for example, Com. v. Wright, 433 A2D 511, Par.Super. 1981. Selective prosecution. One defendant recently challenged a conviction on the basis that the statute created a classification that discriminated against certain racial and ethnic groups, and against poor defendants. The California Appellate Court held that the statute's classifications did not result in or promote selective prosecutions, and rejected the defense. See People v. Gregory, 192 Calories.rptr. 555, Cal.App. 4th Dist. 1983. Evidence. The evidence in a criminal non-support action should not differ markedly from that in a civil contempt case, unless the defendant asserts non-paternity as a defense. In most cases, the most important issues will be the defendant's state of mind, his or her financial condition during the relevant period, and the needs of the children. Many courts have held that a culpable mental state can be inferred once the prosecution establishes neglect. Com. v. Wright, Supra, Dyer v. State, 52 P2D 1080, Oklahoma. Crim. 1935, State v. Faulkner, 182 NC 793, 108 say 756, 1921. In California, once the prosecution shows the omission to provide support, the burden of proof shifts to the defendant to prove that the omission was not willful or excusable. People v. Temple, 20 calories. App. 540, 97 calories. RPTR. 794, 1971. Ability to pay may be more difficult to prove in a criminal case than in a civil case because the defendant cannot be forced to testify, except in those states where inability to pay is an affirmative defense. Presumably, records of the defendant's employer, or of the state revenue or employment security agency could be submitted. If that fails, perhaps friends or relatives of the defendant could be called to testify regarding the spending habits of the defendant during the relevant period. The needy condition of the children can be proved with the testimony of the custodial parent or, for an AFDC case, by placing the welfare agency's grant history into evidence. Seacom v. Hussey, Supera. Punishment. Once the defendant is convicted, the court must fashion a form of punishment that is severe enough to make the defendant change his or her behavior in the future, and yet which does not make it impossible for the defendant to earn a living. The court usually can achieve these ends by sentencing the defendant to an appropriate jail term, called shock detention, and then placing the defendant on probation. The conditions of probation normally will require the defendant to pay a certain amount of child support, and perhaps take other action to make it less likely that he or she will not repeat the offense, that is, enter a drug or alcohol rehabilitation program. Many appellate courts have upheld a trial court's authority to enter a permanent support order as a condition of probation as well. See Murphy v. State, 171 Arc. 620, 286 SW 871, 1926. Martin v. People, 69 Colorado 60, 168 p. 1171, 1917, State v. Waller, 90 Can. 829, 136 p. 215, 1913, Poindexter v. State, 137 Tennessee 386, 193 SW 126, 1917. However, in some states the trial court may only enforce a current support order for the maximum period a defendant can be placed on probation, which will vary with the length of the sentence imposed. In Los Angeles County, California, the district attorney's office uses the following guidelines to recommend sentences in misdemeanor cases. The defendant should be placed on summary probation for 2 years. A fine should not be imposed. The court should enter a current support order based on the guidelines used to set orders in civil cases. The court should consider the defendant's ability to repay public assistance paid to the family during the period of the crime. A wage assignment should be effected. Jail time should be recommended only where necessary. In many jurisdictions where the court deems jailing to be appropriate or necessary, it is possible for the defendant to serve the sentence on weekends and evenings in order to continue working. Tax refund interceptions. One of the most effective collection remedies in recent years has been the interception of federal and state income tax refunds owing to delinquent absent parents. In tax year 1984, tax processing year 1985, 1,287,717 cases were submitted to the Internal Revenue Service, IRS. The IRS certified 1,083,856 of these. By the end of the year, 489,366 refunds had been intercepted, totaling almost $240 million in gross collections. Complete figures for tax year 1984 can be found in Child Support Enforcement, 10th Annual Report to Congress for the period ending September 30, 1985. To be published by DHHS in 1986. As of April 1986, 1,661,000 cases had been submitted for offset processing from tax year 1985. Of these, 227,000 were for non AFDC cases and 1,434,000 were for AFDC cases. States have reported similar successes intercepting state tax refunds. For instance, in 1981, Oregon collected $3 million. Congress responded in 1984 by enacting 42 U.S.C. 666-3, which requires all states to enact and implement procedures under which state tax refunds can be intercepted for both AFDC and non-AFDC cases. Federal Tax Refund Interception Program. Section 2331 of PL 9735. The Omnibus Budget Reconciliation Act of 1981, added new Section 464 and new paragraph 454, 18, to Title 4D of the Social Security Act, 42 U.S.C. 664 and 654, 18, respectively, and amended Section 6402 of the Internal Revenue Code, 26 U.S.C. 6402. C. The combination of these statutory amendments created a new remedy by which an absent parent's federal income tax refund could be reduced by the amount of any arrearage that has been assigned to a state and certified to the IRS for set-off. Section 464 was revised by the Child Support Enforcement Amendments of 1984 to extend use of the remedy to collection of past due support in non-AFDC and foster care cases. This revision is effective for refunds payable after December 31, 1985, and before January 1, 1991. Intrastate procedure. 45 CFR 303.72 governs use by the states of the federal tax refund set-off remedy. Under the 1985 revisions, there are separate qualifying criteria for AFDC and non-AFDC cases. For AFDC cases, the amount of past due support must exceed $150 and must represent a delinquency of at least 3 months. For non-AFDC cases, the support delinquency must be entirely child support, no spousal support component, must exceed $500, and must not represent support previously assigned to the state. In addition, the state may opt to consider for set-off in non-AFDC cases only the delinquency that has accrued since the state began to enforce the support order. For both types of cases, the 4D agency must possess a copy of the support order and all subsequent modifications and a copy of the payment record or an affidavit signed by the custodial parent attesting to the amount of support owed. In non-AFDC cases, the record must include, additionally, the custodial parent's current address. Also, before submitting the case to Oaks, the 4D agency must verify the accuracy of the absent parent's name, social security number, and delinquency and check its records to determine whether an AFDC or foster care arrearage exists. Each state 4D agency must submit annually to Oaks a magnetic tape identifying cases for potential refund interception. The tape must separate AFDC and foster care cases from non-AFDC cases. Oaks reviews each submittal to determine whether the above criteria have been met. If all is in order, Oaks transmits the submittal to the IRS. The 4D agency must inform Oaks of any cases to be deleted or delinquencies to be decreased. 2 notices must be provided to the absent parent. Oaks, or the 4D agency if it elects to do so, must send a written advance notice to the absent parent, informing him or her of the right to contest the state's determination that past due support is owed or the amount of past due support. An administrative review by the submitting state or, at the absent parent's request, the state with the order on which the referral for offset is based. In addition, the notice must notify the absent parent of the procedures and time frame for contacting the 4D agency to request administrative review and that, in the case of a joint return, the IRS will notify the absent parent's spouse at the time of offset regarding the steps to take to protect the non-debtor spouse's share of a joint refund. A second notice must be sent by IRS at the point the refund is intercepted. If the absent parent responds to either notice by requesting a review, the 4D agency must notify both the absent parent and, in non-AFDC cases, the custodial parent of the time and place of the administrative review. If the review results in a deletion of, or decrease in, the amount referred for set-off, The 4D agency must notify OAKS promptly if the set-off has already occurred. The 4D agency must make any necessary refunds promptly. Interstate procedure. In interstate cases, the submitting state must notify any other state involved in enforcing the order, both upon submittal to OAKS and upon receipt of the refund from IRS. The requirements regarding notice to the absent parent are the same as for interstate cases. The most significant procedural change pertains to the administrative review process. The submitting state must provide the absent parent an opportunity for review. If the complaint cannot be resolved by the submitting state and the absent parent requests a review in the state with the order on which the referral for offset is based, the submitting state must notify the other state and provide all necessary information, including a copy of the order and all subsequent modifications, a copy of the payment record or the custodial parent's affidavit, and, in non-OFDC cases, the custodial parent's current address. The rendering state must schedule the review, notify both parents, conduct the review, and make a decision within 30 days of receiving the referral from the submitting state. The rendering state must notify the submitting state promptly of its decision. The submitting state is bound by the rendering state's decision, and must refund promptly any amount ruled to have been intercepted in error. Distribution of intercepted tax refunds. Collections received by a 4D agency as a result of a federal tax refund interception, both for AFDC and non-AFDC cases, must be distributed as past due support pursuant to 45 CFR 302.51b4, and 5. These sections require the state to retain such amounts as are necessary to reimburse itself for public assistance paid during any sequence of months for which it has not yet been reimbursed. This amount is shared with the federal government to the extent of its participation in the assistance payments. Any amount left over is to be distributed to the family. If a state fails to submit its arrearages for offset, the non-AFDC offset goes entirely to the family. If both arrearages are submitted, the state gets its payment first. AFDC and foster care assigned arrearages will be offset by the IRS before non-AFDC arrearages, which are not assigned. Legal challenges. The federal tax refund interception program has been challenged in state and federal courts, primarily on the following three grounds: that due process requires a pre-deprivation notice and opportunity for hearing. See Nelson v. Regan, 560 F. Sup. 1101, D. Connecticut 1983, Marcello v. Regan, 574 F. Sup. 586, DRI 1983, Jan v. Regan, 584 F. Sup. 399. E. Michigan 1984, Keeney v. Secretary of the Treasury, number 83 2427, C. California the 10th of November 1983, Presley v. Regan, number 83 CV 630, DNY the 3rd of November 1985, that the interception of joint refunds, without adequate notice to the non-debtor spouse regarding the procedure he or she must follow to protect his or her share of the refund, violates due process. See Coughlin v. Regan, 584 F. Sup. 697, D. C. Main 1984, Jan v. Regan, Supera. That the earned income credit portion of a federal tax refund is not an overpayment and thus is not eligible for set-off. See Sorensen v. Secretary of the Treasury, 752 F2D 1433, C. A. 9, 1985, number 84 1686, Rucker v. Secretary of the Treasury, 751 F2D 351, C. A. 10, 1984, F. 555 F. Sup. 1051, D. Colorado 1983, Nelson v. Regan, Supera. The procedural modifications effected by the 1985 federal regulations appear to alleviate the two due process concerns, that is, notice and hearing procedures. The earned income credit decisions have tended to be adverse to the child support enforcement program, but the issue is presently before the U.S. Supreme Court. State tax refund set-off procedures. The 1984 amendments require states to have laws providing for state tax refund offset. Most states that have an income tax have indeed enacted set-off statutes, authorizing the state revenue agency to withhold tax refunds due individuals who owe any liquidated debt to any state agency. The procedure is similar to the federal set-off procedure, with the state revenue agency performing a role similar to that of IRS. A broadly based statutory and constitutional challenge to the Oregon set-off procedure was mounted by the Oregon Legal Services Corporation and rejected by the Oregon Court of Appeals in Brown v. Lobdell, 36 or.app. 397, 585 P2D4, 1978. The Maryland statute was held to violate due process, for lack of pre-deprivation hearing, in McClelland v. Massinger, 600 F.Sup. 558, 11 Floor 1132, D.MD. 1984. Bonds and other security. The Child Support Enforcement Amendments of 1984 require states to enact and use procedures which require that an absent parent give security, post a bond, or give some other guarantee to secure payment of overdue support, after notice has been sent to such absent parent of the proposed action and of the procedures to be followed to contest it, and after full compliance with all procedural due process requirements of the state. The remedy need not be applied in all cases, but the state must determine that each case is not appropriate using guidelines generally available within the state which take into account the payment record of the absent parent, the availability of other remedies, and other relevant considerations. A majority of states have enacted legislation authorizing courts to require a non-complying obligor to post a compliance bond or provide other security. Presumably, now that states will be turning to expedited judicial and administrative processes for enforcement of support obligations, the authority to require bonds or other security will be conferred on judge surrogates as well. The remedy may be combined conveniently with a civil contempt proceeding. Where the obligor is found in contempt, the court might order that he or she post a bond or give over title to real or personal property to secure future compliance. Upon non-compliance, the security is liquidated at the direction of the court, usually ex parte, and the proceeds are applied to the support obligation. In many states, due process no doubt would require that notice and a hearing, pre or post liquidation, be provided to determine whether the obligor did or did not comply and to allow him or her to assert any available defenses. A thorough statute will set forth a clear procedure. In the past, the remedy has been more theoretical than actual. Bonding companies have been unwilling to provide what is in essence child support insurance, perhaps due to the low level of compliance. The passage of federal legislation is not likely to change this attitude. Therefore, it is more effective to seek security only where a specific piece of property has been identified that, for one reason or another, is not appropriate for seizure by way of execution. Where the obligor's personal interest in the property is high, financial interest is low, and storage and sale costs are likely to be high, asking the court to order the obligor to put the property up as security would encourage future performance. A good example of such property would be a motorcycle or a boat. The obligor may get sufficient pleasure out of the item to make it worth more than the amount of support he or she might have to pay to comply with the order. It also might be possible to convince a court to order a high-income obligor to set up a trust out of which the support payments could be made. Equitable remedies. Most state courts that sit in child support cases possess equity jurisdiction. If equity power is not specifically provided for by statute, case law often can be found to support the use of equitable remedies to enforce child support obligations. Indeed, contempt is often referred to as an equitable remedy. Two other equitable remedies that can prove useful are niexeat and receiverships. Niexeat. The writ of niexeat issues from a court of equity to restrain a person from going beyond the limits of the jurisdiction until he has satisfied the movant's claim, or has given bond for his appearance or for satisfaction of the court's earlier decree. The writ existed at common law, so many courts have held that it is available in domestic relations cases even in the absence of statutory authority. Lamar v. Lamar, 123 Georgia 827, 51 say 763, 1905, Anderson v. Anderson, 315 111. App. 380, 43 NE2D 176, 1942, Nixon v. Nixon, 39 WIS.2D 391, 158 NW2D 919, 1968, Bronk v. State, 43 Fla. 461, 31 So. 248, 1901, Cohen v. Cohen, 390 Mass. 31, 64 NE2D 689, 1946. The purpose of the writ is to restrain an individual from leaving the jurisdiction, so it generally requires an allegation and proof that the individual is about to leave. Aiken v. Aiken, 81 So 2D 757, Fla. 1955, the court holds a hearing ex parte, similar to the hearing held in an injunction proceeding. McGee v. McGee, 8 Georgia 295, 8 ALR 330, 1850, if granted, the court may order the sheriff to apprehend the obliger. After the obliger is brought into court, a hearing is held to determine the amount of the appearance bond to be filed. The bond may be set to ensure the obliger's appearance at a hearing required by another civil enforcement remedy, or perhaps, to ensure his or her compliance with the order after he or she leaves the jurisdiction. See Gibson v. State, 220 Miss. 39, 70 So 2D 30. 1954. Receivership. A receiver is an individual appointed by the court to take the property or funds of a party to an action, generally pending the outcome of the action. In domestic relations cases, receivers usually are used during the pendency of a divorce action where there is some danger that one of the parties will squander or waste the property or funds. There is likewise some authority for their use during the enforcement stage, at least where the court that entered the order possesses equity powers. The state of Michigan has a receivership statute specifically designed for child support enforcement. Receivers are appropriate for use against self-employed absent parents who have an identifiable business. The court appoints a receiver to operate a business on behalf of the obliger. The proceeds of the business, less the receiver's expenses and fee, are turned over to the court for application on the child support obligation. Receivership is an extreme remedy and one that asks the court to use its equity powers. As a result, if an available legal remedy exists, the court is well within its rights to demand that the legal remedy be tried first. Fincham v. Fincham, 174 Can. 199, 255 P2D 1018, 1953. In practice, the remedy should not be as drastic as it first appears. Most self-employed absent parents will be quick to make other arrangements for paying arrearages and ensuring current support. Reports to consumer reporting agencies. Pursuant to 42 U.S.C. 666, A7, states must have laws in effect providing procedures by which information regarding the amount of overdue support owed by an absent parent residing in the state will be made available to any consumer reporting agency, as defined in Section 603F of the Fair Credit Reporting Act, 15 U.S.C. 1681 AF. Upon request of such agency. The procedure must be available in cases where the amount of overdue support exceeds $1,000. Subject to the state's authority to limit the remedy to appropriate cases using guidelines which are generally available within the state and which take into account the payment record of the absent parent, the availability of other remedies, and other relevant considerations. Consumer Reporting Agency is defined by 15 U.S.C. 1681 AF to mean any person who for monetary fees, dues, or on a cooperative non-profit basis, regularly engages in whole or in part in the practice of assembling or evaluating consumer credit information on consumers for the purpose of furnishing consumer reports to third parties, and which uses means or facility of interstate commerce for the purpose of preparing or furnishing consumer reports. 45 CFR 303.105 sets forth the procedural requirements a state must meet in order to comply with 42 U.S.C. 666. A 7. 45 CFR 303.105, d, requires the state to provide the absent parent advance notice and an opportunity to contest the accuracy of the information to be provided to the consumer reporting agency. In carrying out the notice and conflict resolution process and prior to release of information, the state must comply with its applicable due process requirements. Paragraph C of the regulation allows the state to charge the consumer reporting agency a fee to cover the costs of providing the information. Full collection by the IRS. To use this remedy, the state must submit requests for a certification to the Oaks Regional Representative. 45 CFR 303.71d, 1. Only the State 4D agency may request the certification. There must be a court or administrative order for support entered against the individual. Reasonable efforts must have been made to collect the amount owed, the state must have an assignment of support or application for services, and the delinquency of the order cannot be less than $750. Certification will not be allowed if there has been a request for certification in the case during the previous 6 months. The state must agree to reimburse the United States for costs involved in the collection. The fee for the service is $122.50. A state's request must include the following items: sufficient information to identify the debtor, including the individual's name, the individual's social security number, the individual's address and place of employment, including the source of this information and the date it was last verified, a copy of all court or administrative orders for support, the amount owed under the support order, a statement of whether the amount is in lieu of, or in addition to, amounts previously referred to IRS for collection, a statement that the agency, the client, or the client's representative has made reasonable efforts to collect the amount owed using the state's own collection mechanisms or mechanisms that are comparable. A description of the actions taken, why they failed, and why further state action would be unproductive. The dates of any previous requests for referral of the case to the Secretary of the Treasury. A statement that the agency agrees to reimburse the Secretary of the Treasury for the costs of collection. A statement that the agency has reason to believe that the debtor has assets that the Secretary of the Treasury might levy to collect the support. A statement of the nature and location of the assets, if known. The Oaks Regional Representative reviews the request to determine whether it meets the above requirements. Next, the regional representative either forwards the approved request to the Secretary of the Treasury or consults with the state in an attempt to correct any deficiencies. 46 Oaks has indicated that it prefers cases in which the delinquency exceeds $2,000 and where the absent parent resides in a state other than the requesting state. The IRS will attempt to collect the amount certified like a tax delinquency, except that no interest or penalty shall be collected. The property exemptions contained in 26 U.S.C. 6334 are 4, 6, and 8, do not apply. As much of the salary, wages, or other income of an individual as is being withheld in garnishment for the support of that individual's minor children shall be exempt from levy pursuant to a judgment entered by a court of competent jurisdiction. In the case of the first assessment against an individual, the collection shall be stayed for a period of 60 days immediately following notice and demand. The 60-day stay described above presumably gives the obligor the opportunity to satisfy the arrearage or contest the amount of the arrearage claimed by the state. No federal court has jurisdiction to restrain or review the assessment or collection. However, this does not preclude the individual from bringing legal, equitable, or administrative action in the appropriate state court or administrative body to determine his or her liability for any amount assessed against him or her, or to recover any such amount collected through this procedure. Mandatory military allotments. Section 465 of the Social Security Act requires allotments to be taken from the pay and allowances of any active member of the uniformed services who owes the equivalent of 2 months or more in court ordered child support or child and spousal support payments. The requirement also applies to commissioned officers of the Public Health Service, an agency within the DHHS, and of the National Oceanic and Atmospheric Administration, an agency within the Department of Commerce. Procedure. The mandatory allotment procedure is initiated by the 4D agency, or the court or agency that has the authority to issue an order by sending a notice to a designated official within the uniformed service involved. These officials are identified in Appendix II of the Garnishment Regulations issued at 5 CFR 581. The notice can be given in the form of a court order, letters, or other document. The contents of the notice vary from one branch of the service to another, but generally must provide the full name, social security number, branch of service, and duty station of the member who owes the support obligation. Specify the amount of support due, and the period in which it has remained owing. Be accompanied by a certified copy of an order directing the payment of this support issued by a court of competent jurisdiction, or in accordance with an administrative procedure that is established by state law. Provide the full name, social security number, and mailing address of the person to whom the allotment is to be paid. Identify any limitation on the duration of the allotment. Identify the name and birth date of all children for whom support is to be provided under the allotment. The notice and accompanying documents are served by certified or registered mail, or by personal service, on an official designated by regulation. On receipt of the notice, the uniformed service must provide a copy to the absent parent and arrange for a consultation between the absent parent and a judge advocate, or a representative of the service's legal staff. The consultation allows the absent parent and the judge advocate to discern what factors are involved with respect to the support obligation and failure to make payments. The allotment may not be instituted until this consultation has been provided, or 30 days after the absent parent received notice of the delinquency. The amount of the allotment is the amount necessary to comply with the order, which, if the order so provides, may include arrearages as well as amounts for current support, except that the amount of this allotment, together with any other amounts withheld for support from the wages of the member, shall not exceed the limits established by the Federal Consumer Credit Protection Act, 15 U.S.C. 1673, b. 521. Statutory examination of a judgment debtor. One of the most frustrating situations is the self-employed absent parent or the absent parent who is paid by cash and, therefore, can continuously avoid contempt by claiming inability to pay. Without any evidence as to the obligor's income or assets, there is little the attorney can do to counter the absent parent's claim of inability to pay. This problem apparently presents itself to numerous judgment creditors, because many state legislatures have provided all judgment creditors a remedy suited to this very situation. Typically, an execution first must be returned unsatisfied by the sheriff. The attorney, if he or she doesn't know of any goods or property on which levy may be made, should request the sheriff to make such a return. A motion then must be filed with the court that rendered the judgment, requesting an order requiring the defendant to appear at a time and place named in the order to be examined under oath concerning his or her ability to satisfy the judgment. Some statutes require the plaintiff to show by affidavit or otherwise that there is reasonable ground to believe that the defendant has property subject to execution or has conveyed or attempted to convey his or her property with an intent to defraud his creditors. The court then holds a hearing to examine the defendant. The process, when successful, results in a finding that the defendant owns property which ought to be applied towards satisfaction of the judgment, as well as an award against the defendant for the costs of the examination. If the defendant is found to be actually without property, the costs are charged to the plaintiff. Unfortunately, a constitutional imitation may hamper the effectiveness of the remedy. In State Ex Rel. North v. Kirtley, 327 SW2D 166, Mo. 1959. The Missouri Supreme Court held that a defendant could not be required to answer questions as to the ownership of property when he based his refusal upon the privilege against self-incrimination, and when the examination was, in effect, a charge of fraudulent conveyance of property, a misdemeanor. An argument could be made that the privilege applies in states where criminal non-support is a possibility.